Hello, good morning, and welcome to Newsfile. This is your most authoritative news analysis show, and on this show, we put Ghana first. Today, I have a few questions and one statement by way of introduction. The Supreme Judgment, tainted by politics and simply a corrupt judgment, will Chachu's quote-unquote truth, for which he owes no apology to the judge he accuses of political bias, survive the fact check? I don't know if Gabi's corrupt judgment label, for which he is prepared to go to jail, will pass the test either. Number two, same Supreme Judgment. How do you understand it and claims of its implications on future elections? We hear from the petitioners and the respondents. Will they adopt a literalist or liberal purposive approach to interpreting the judgment? And very finally, the NPP won't allow Nana Akufo-Addo to enjoy his little time out to rest, reflect on his political future. Compelled, he announces he needs to hear from his maker if he should accept, this time without struggle, an invitation to lead the party into the 2016 elections. Is he the NPP's key to the Flagstaff House in 2016? We'll be right back.
The majority upheld that really there was a certain discretion, okay, because in terms of the purposive interpretation, biometric verification is to just ensure that you are the one who is coming to do the voting. And it does not supersede the right to vote. In other words, whether we use a machine or we use some other means, once a person is properly identified as the one who has the right to vote or is the proper person registered to vote, then you must go ahead. Now, in the event that we had machines to help us do that, we will do it. But if we did not have machines to help us do that, and there was the proper officer, the presiding officer, etc., who was able to identify you sufficiently, and use other means, administrative means, to verify you, it was not good enough for your vote to be annulled simply because a machine was not used. So, in essence, that is what the majority side is saying, that yes, biometric verification, but it does not have to be dependent only on a machine. And if there are other ways to do it and it is done, much as it is not perfect, it is not good enough to annul a vote because of that slip. And so they went that way. From reading the judgment, as it's been given, you have two schools of thought. So I use an analogy. If you have a polling station where 100 people are registered, but only 60 people turn out to vote, in a perfect situation, you have 60 ballots in the box. Now, the judges are saying that if you have 100 people registered and 60 people turn up to vote, but then you find 65 votes in the ballot, it is not overvoting because there were 100 people registered to vote, regardless of the fact that 60 people turned up to vote. The 5 extra is what they are calling stuffing. Okay, now the minority is saying that if you have 100 people registered and 60 people turn out to vote, then anything beyond 60 is overvoting and should be treated as such. So you have these two schools of thought. One saying that you can't have overvoting if the number of registered voters has not been exceeded. The other is saying that it is overvoting if the number of people who were present at the polling station were exceeded. So these are the two views. And the majority is on the view that if it does not exceed the number of registered voters, it is not overvoting. And that is the law as it stands today.
The issue of overvoting and vote verification, the petitioners should not only rely on P sheets to the majority, especially the Zatugba, the P sheet is nothing because it does not have any constitutional definition. There's no constitutional definition. There's no statutory definition. So the P sheet is just a mere paper that we presiding officers have to account to whatever happened at the police station, and then to them, as Riley said, he saw a lot of errors, administrative errors on the P sheets, grammatic errors, numerical errors. So by the P sheet alone, it is not enough to rely on it to determine what overvoting and voting by prediction means. So to the majority, led by Atuguba, the petitioners failed to produce other evidence to support their case. Of the majority decision when it comes to signature. They hold the view that, look, the signature of the presiding officers, although constitutionally mandatory, there's a sharp provision. But they believe that, look, when you are interpreting the Constitution, don't look at the letter. Don't look at the strict interpretation. Go beyond the letter and look at the spirit and then the purpose for which that provision was made. And to them, the purpose for which that provision was made is to ensure that at every police station, you can verify and authenticate the results by either signing of signature by the presiding officer and then polling agents of the party. In looking at the Constitution, you don't look at ordinary and literal meaning. Look at the spirit. Don't look at the letter, look at the spirit, and look at the purpose. And to them, the purpose for signing is to authenticate and then validate the results. So if party agent did sign, and after signing, they authenticate, and then after signing, the results went to collation center, no complaint was made, it was authenticated, signed, and then it went to the strong room. Then it will be unfair and unjust and fraudulent on the part of the petitioners to come and raise technicality that, look, presiding officers did not sign, therefore the votes should be annulled. So the minority position is that we cannot give any excuse for not signing. The presiding officers are not only officers alone, they are officers of the EC, and their signature validates. So the Constitution is quite clear. There's no issue of interpretation. So they don't agree with the majority position that we ought to apply a purposive approach. That's the purpose, and then the spirit is clear. He said, you, the presiding officers, you shall. So straightforward, there's no problem of interpretation. So the minority is saying that, look, don't let us use interpretation theories and principles to overlook a clear constitutional duty. They refer to constitutional duty. Whilst the majority are looking at administrative duties of the presiding officers, the minority is saying that it's not administrative, it's constitutional duty. Therefore, the judges are called upon to protect and preserve the Constitution. So to them, the majority have failed in that direction in protecting and defending the Constitution, because they have allowed violations and then they are using technicalities of the law to justify the violations.
So Chikata should not behave like all is well and therefore he's won the case, hands down, and he should gloat, as it were. Indeed, if his whole analysis is to go by, if we were to extend his reasoning that because Justice Eni Yabua was appointed by His Excellency J. Kufuor, which is why he was doing the bidding of the NPP. Everybody knows that Atuguba was appointed by Rollins, Bedegbe was appointed by Mills, NDC, Akute Banfo was appointed by Mills. So is it because of that, that is why they did not find a single reason even to stand on? Is that the reason why? Going by Chikate's in analogy, I think that that's what it is. And we must, like he puts it, we must also be frank in confronting those. Chikate's outburst is unfortunate. It is, with respect, out of order. I will not use the word nonsensical, because that would be too high-handed. But it doesn't make sense whatsoever. And he should know better. He is a law lecturer. He is completely got it wrong. He should be the first person to be humble enough to come and apologize to the bench, to the country, and to the New Patriotic Party and the petitioners. But if he says he won't do it, will leave him to his conscience. Ghanaians, it is posterity that will judge him. Where we are, it's not about Akufo-Addo. Ghanaians need him. His country needs him. The party needs him. And it is for their sake that Akufo-Addo would return in 2016 and take this country to better heights. And so that decision certainly will not be the decision of Akufo-Addo. If the voice of the people is the voice of God, then we are calling on Akufo to listen to the voice of the people. And the voice of the people on the ground is that they need Akufo-Addo. I've heard people talk about age. Now laugh. Age. You have some people who are 45 and yet they are so weak that they cannot even move. You understand? There are people who are 70, 80 and yet they are solid as the rock of Gibraltar. Akufo-Addo is in that league. I have seen Mugabe moving with some agility. And he's still there. Some 80 what? 83, 85? Still there. Still going strong. I have seen the Israeli president over 92, 93 years. He's the president of Israel, one of the most powerful countries in this country, in the world. He's there, the president, 93-year-old. You know Salif Johnson? Liberia. You know how old she is? About, I think, 76. She's still the president of Liberia, and she's going for another 5 years or thereabout. You add it up, she will still be there. Akufo-Addo will be 71 in what? 2016, and he cannot come. People are joking. They don't get it. They don't understand politics. I can tell you Akufo-Addo will be there in 2016. Inshallah.
We're being watched by millions of people in Ghana on over a dozen affiliate stations and across the globe. In the UK, this is the ABN TV Sky Channel 290. And you're also watching on www.multitvworld/streams or listening at myjoyonline.com. However you are listening, you're welcome. Your views are also welcome. 1422, that's the text line, 1422, or send them to, post them on our Facebook wall as well. You can put them to the email, via email to newsfile@myjoyonline.com. My name is Samson Ladi Ayenine, and I welcome you once again. This show is brought to you by the kindest sponsorship of MTN Everywhere You Go, Bank of Africa, strong as a group and close as a partner. Lipton Tea, inspiration flowing from nature. Valex Lease Equipment, your affordable document management solutions company. Lease a modern multifunctional equipment for your scans, copying and printing. And I am dressed or clothed by Latida. Now, I want to welcome my guests who are already seated in the studio. Abdul Malik Wekubako Jr. is editor-in-chief of the New Crusading Guide newspaper, a regular panelist. Gabi Asare-Ochiridako will join us shortly. He is a lawyer, executive director of the Dankwa Institute. Nana Atodazi, he is a lawyer and a former chief of staff. Alex Segbefia is a lawyer and deputy chief of staff, former. Thank you very much. Good morning, gentlemen, and welcome to the studios. Right. And as you may have heard, my announcement by way of questions on the Supreme Judgment that I'm asking, is the judgment tainted by politics or is simply a corrupt judgment? And you may know where I'm coming from. And I'm asking, will Chachu's quote-unquote truth, for which he owes no apology to the judge he accuses of political bias, survive the fact check? We'll put it through the fact check and see if indeed Chachu is speaking the truth as he insists. And as I indicated, I don't also know if Gabi Asare-Ochiridako's corrupt judgment label, for which he also is prepared to go to jail, like his grandpa did, for standing for what he believes in I don't know if his will also pass the test. And then, that's just by way of the preliminary, interlocutory matter. We'll just deal with it quickly and dispense with it. And then we'll come to the judgment proper. We're looking at it from the perspective of the petitioners and the respondents. What is the attitude that they will adopt in interpreting it? Literalist, constructionist, or liberal, benevolent, purposive approach? Good morning and welcome once again. I'll start with you, Alex. You were first here, so good to start with you. Yeah. All right. So, Mr. Chachi Chikata gave an interview to TV3, Hot Issue, a new program hosted by Kwesi Pratt. In the course of the program, Kwesi asked a question. It appears that 3 of the judges consistently voted against the petitioners. And his response is that he is not surprised at that. He singles out Justice Eninyebua and says he doesn't do a judicial balance. What he has done has been to consistently vote against the petitioners, and that he refers us to his political leaning, so to speak, that he was appointed by President Kufuor, and so he's not surprised. And then he goes to tell us about a case, the IFC case, in which he thinks that the judge also, did something for a political purpose. Chachu has come under such a deluge of condemnation. Some say fair. You say not exactly fair. He says he won't apologize. What do you say?
Well, good morning to yourself and the co-panelists, and more importantly to your viewers and listeners.
And Gabi is now with us. He's on the show. Gabi, good morning.
Morning.
Great to have you.
It's the first point I would make is that you have to decide as an individual or a group which hat you wear when you want to draw an analysis of what has happened. The first thing that I will point out is that Chachu has already come out and defended himself, so there's no need technically for anyone to go beyond what he says, because he's granted another interview on a sister station of yours where he goes into some more detail as to the basis of his decision, of his statement, why he made it, and why he stands by what he said. He also explains why he doesn't believe it amounts to any form of contempt. And I think that I cannot do more justice to his explanation than for people to actually listen to that interview that he put out himself. I can totally understand why there has been a deluge of criticism of his statement. And therefore, if you're wearing, and I use my words advisedly, a neutral hat, or for that matter, a very patriotic hat, then I think that you would say that the words at the time when it came, and including the language, were unfortunate, could have been used in a different, or said in a different way. But if you wear a political hat, then you take a totally different posture. And unfortunately, or fortunately, this case has clear political connotations linked to it. So you cannot take away the politics from it.
Justice Atuba noted that during the trial.
Exactly.
That it has 2 sides.
Now, the first question I ask is that, is this unique to, what's it called, the position in this particular case? I want to know whether all those who, and this is now looking at it from the political angle, as opposed to the first time a judge was criticized in this case was done by the petitioners.
Okay, hold on.
Yeah.
Before you move on to that, I want to know what you say about Chachu's comments. Are they factual? He says what he says is the truth, and that is what we should be paying attention to, that Justice Eninyeboah consistently from the start appeared to be against the respondents and indicated so in the end.
I think that it would not be, and that is, I stand by what I'm saying, it would not be right for anyone here to fuel further what may have been said, whether right or wrong. Chachu has put his justification forward.
Yes.
Any statement anybody makes regarding actually going into the factual basis, you then get yourself into the fray. And there is, for me, there's no need to get into the fray. Chachu, unlike some have made statements and withdrawn, nothing has been done, or have not been able to justify it. He has put forward why he says this is, and put it out there. You either take it or you leave it.
You take it, or what do you do with it?
Well, it is not for anybody, I humbly submit, on this panel who has the act to deal with anything Chachu has said.
There are millions of people all over the globe who are watching us.
Yes.
This platform is part of shaping the national discourse.
I don't have a problem with that.
What Chachu did, is it the way to go?
Well,
if
that's
you
what I'm
have
saying.
an issue with the judge,
well,
for
no.
example,
that is why I'm
correct.
saying that you cannot look at Chachu's situation in isolation if you are wearing a political hat. And why am I saying this? The first incident of an attack on a judge happened at the beginning of this case when Justice Atuguba's, the petitioners, not just one, the petitioners made in open court a statement that because of Justice Atuguba's links to the, what's it called?
Open court?
No, it
in
was
chambers.
in chambers. But it came out. Let me put it so it came into the public domain. Well, Gabi, it is not a question. I'm just saying that this is the fact of the matter.
It became known
knowledge
because the respondents wanted it to be known. The petitioners didn't disclose it.
Well, for me, I'm saying it is neither here nor there.
Why not?
Because they withdrew it. They withdrew it. Why? Why did they withdraw it? It was in the public domain.
Okay.
And once it got into the public domain, they withdrew it. Why?
Is that the reason they withdrew it?
They decided they were not going to pursue that line any further. But the line was there in the public domain.
The approach they took, is it allowed by law?
Are you saying that what Chachu has done is unlawful?
No, I'm asking first of all.
Then in that case,
you're using the petitioners as an example.
But your question should be based on the fact that maybe what Chachu has done is unlawful. And I'm saying that if it was unlawful, then by all means, you can ask the question about whether the petitioners, because I've never made any claim here that what the petitioners did was unlawful.
Okay.
I have not.
All right.
They didn't do anything unlawful, but they challenged it.
But they used the right channel, did they?
Correct.
Was Chachu's the right channel in challenging a judge, in raising bias against a judge?
That is why I have said that if you're wearing your patriotic and legal hat, then if I put the whole thing in the equation, I would say that the timing, along with other things, were unfortunate. And why do I say that? I think that a lot of things have been done which actually were unfortunate. One, the challenge of Atuguba, whether in chambers or out of chambers, was unfortunate. Should not have been done. Because it was even done before the judgment came out. I think that was unfortunate.
All right.
I also think that the, statement that my dear friend who is going to justify it here said, Gabi, was unfortunate. I don't think it should have been done. I then, in that card, if I'm wearing a patriotic hat, we would then say, yes, if I'm going to go down that road, then it is also correct to say that what Chachu said should not have been done. But both Gabi and Chachu stand by what they say, which is significant, because that was the same thing that happened with our dear friend who was down for contempt, the editor of Ken Crunchy. He said, look, I stand by what I'm saying. When it was put before the court, they found that he had crossed the line, and they dealt with him. But he still says, I stand by, because he feels he was protecting freedom of speech.
Right.
The same way Gabi has said, well, I think that what I said is appropriate. I'm making a judgment of the case, and therefore, even if I have to go to jail, fine. So why should Chachu be the one that needs necessarily to be apologizing? Let's put everything in the same boat and make a decision. But to single out one person constantly for criticism, I think that, for me, it's not the way forward. And actually, I think that the president got it right when he says there should be a ceasefire. Unfortunately, not only this, I've heard it on other studios, it's become flavor of the month, so everybody is discussing this topic. And no matter how you run away from it or not, it is the topic. And so people need to have an aspect. But I think that I must give Chachu credit for his explanation. Because he says, I have made or said something which many people have done in many cases. There have been situations where judges have made decisions. As a political party, if you remember, even when Chachu was jailed in court, we all, as a political party, criticized the manner he was dealt with, the way the judge had flaunted, we say, rules of natural justice.
Sure.
This, that. It was, we all did it. So if we've done this in the past in other issues, it is perhaps the timing, because coming so close to the verdict, that may be an issue. But it is not new. This criticism of a judge and saying, or of a judgment or a judge in terms of posturing or how the person, it is not new. What you don't do is you don't do it before the judgment. And therefore, this is why I'm saying that even when you talk about the way in which the petitioners put their case forward, at the time they put it forward, it was unfortunate. And yes, they went into chambers, it came out.
No, by the rules, if you have an objection against a judge on the basis of bias, you raise it at the first instance.
I don't
So
have
when
a
you
problem.
say it was wrong,
But if you're going down that road, make sure you are standing on solid ground.
Right.
Why withdraw it? If you really thought you don't start that type of a process and then withdraw it. So, I mean, for me, it was almost like you are sending a warning out to the judge. That's how it came across.
sort of seeking to intimidate the judge.
Exactly. If you have a good ground, put it forward. And let so for me, it is not, everybody's talking about Chachu. Yes, you depend on the hat you're wearing, you may decide one way or the other.
All right.
But he has when you listen to him speak, he has given cogent reasons. He's challenged us as a people to say, look, there are no-go areas. So people don't want to talk about certain things, perhaps.
Right.
But this is something that must be discussed. More or equally importantly, he's made mention, of the fact that I have raised it. People discuss it. But let us be very, 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 very candid. If you're a practicing lawyer and you are going through you know that you have 20, 30 years more before benches and whatnot, you have to be very careful. Whether we like this, a fact, how you speak about this matter, what you say.
You have the benefit of both worlds. You've practiced in England,
yes,
and Ghana as well.
Yes.
Great. Would you do anything like that if you had a problem against the judge?
It depends upon which point of my
any of the jurisdictions.
Legal career.
Would you do that in England or here in Ghana?
I would never do it in
right.
what's it called at this stage of my career.
Okay, let me go around.
But if you are a senior lawyer who has been practicing for years, who is established, who has colleagues on the bench,
right,
who are people who you have dealt with, then certain liberties can be taken, right, and that is also something that happens in the legal profession.
Thank you very much, Alex Segwefia. Nana, I come to you right away. Straight, Church's comments.
Well, again, thank you very much for the opportunity. After 7 or so or 8 months, I believe this is my last lap here. And I hope you excuse me. I mean, I understand your protest, but I think I've served my bit. I mean, I believe that this matter should be put to rest. I mean, this country should move on, and that's really from what point I said that I wish to back out from today on this show. But, you know, me can come back on other matters. But thank you. I'm very happy that I haven't spoken to Chachu so that I can speak my own mind about this matter. You know, like my friend says, I have a problem with the timing, you know, because this is a time when people are seething with a lot of pain, you know. It's a very challenging period for some people. So no matter what you say, you know, you may be saying the right thing, but hey, I mean, the pain will convert what you are saying into something else. And that's the challenge I have with it. Otherwise, I think that Chachu, I will back Chachu in what he says. You understand perfectly where he's coming. What has he said that he said wrong?
So
it's
like
one of perception.
The question I put to Alex.
Yes, I'm responding.
Can we look at it from the factual basis?
Factual basis.
Yeah.
He says that Justice Eni Yabua was appointed by Mr. Kufuor.
Correct.
Is it true or false?
True.
It's true. He hasn't said anything wrong. He says that a judge, and that's what he said. And I believe that the problem we are having here is that the issue, this specific issue, was taken out of context. It's a long interview. It was taken out of context, you understand? He was asked about the leanings of judges, that does politics have a role to play in, what do you call it, in judgment of such a nature?
No, I think this is what happened. He's talking about thinking that the petition was unmeritorious in the first place and ought to have been dismissed. So he's not surprised. Then Kwesi Pratt says, but if you say that, there were judges who disagreed with your position.
Yeah, but this is a summary. This is a summary. But I'm saying that, yes, exactly. But
gives us the right context.
Yes, exactly. The context, I'm saying that you should put it in context. What he was saying was to the effect that, look, you can't take a judge's political or background, you know, leaning out of his judgment.
Right.
And that is an absolutely important point. Look, when we went into court, and I'm saying this is my last say, let me have my say. When we went into court, there were, I would say, millions of Ghanaian NDC supporters who called us at various times asking us, are you sure that this bench can give you the judgment? And their reason was very simple, that 6 or so of the judges were appointed during the tenure of President Kufuor. You know what we told them? Invariably said, no, we believe we have a good case, so it doesn't really matter before we appear. You understand? That's our position. But it was even worsened by the threats or veiled statements coming from various MPP elements, officials. We're saying, look, we have the judges and all that. Look, for me as a practicing lawyer, I'm used to people using, various strategies to threaten, the other side, intimidate the other side. They can't tell you, we have the judges in my pocket. If you don't have the strength, you abandon the case. You understand? But when people like Awuku and others are said to have been making statements about, we have a bench that is favorable. Fine. There's nothing.
You see, Nana, I'm trying to do something. I'm trying to do something so that we get the discussion in a strict context.
Yes.
I agree. That's all right that you could go out of the immediate environment of this discussion and bring, examples to justify what, argument you may be making. But I'm saying we're doing the fact check. You say fact number one. Yes. He says Justice Eni Yeboah was appointed by President Kufuor. That is true.
That's true.
Number two, he says consistently voted against the respondents. You were part of the respondents. Is that fact?
Yes. Except that there were situations where he didn't. But, I'm telling you that within the courtroom, there were situations, body language, whatnot, where our people didn't feel comfortable. But I'm saying that we as lawyers had faith in the panel, as a panel. You understand? There were once, look, what were unspoken, and nobody can deny this. There were once or twice, there were some reaction from the, you don't smile, that's true, because you know it. From the NDC's side, I'm coming.
With the greatest of respect. With the greatest of respect.
Yes.
Consistently, you are avoiding my question.
No, I'm not. The point I'm making is that the makeup, I'm not saying that Mr. Justice Eni Yabwa it's necessarily a pro-MPP or pro-whatnot. I'm saying that Chachu's point is that at a point in time, a judge may tend to fall back into where he came from or how it was done. I will quote this, if you permit me. In the book, this good book, Henry Abraham, Judicial Process, he says, page 66, it's a political and ideological compatibility, if you permit me, often go hand in hand in influencing presidential choices for Supreme Court. Among the points a president is almost certain to consider are whether or not, one, his choice will render him more popular among influential interest groups. Two, the nominee has been a loyal member of the president's party. Three, the nominee favors presidential programs and policies. Four, the nominee is acceptable or at least not personally obnoxious to his home state. Five, the nominee's judicial record, if any, meets the incumbent president's criteria of constitutional construction. Six, the president is indebted to the nominee for past political service. And seven, he feels that the president feels good or comfortable about his choice.
Interesting.
Look, I am saying that I've been involved in this kind of business before. And I know and understand. And no party, no president in the past in this country can say that he simply goes to appoint his, quote, enemy on the bench. You would want to look at the political background, the loyalty, the compatibility. These are all factors in the makeup of a choice. You understand? So we should not run away from it. And I'm saying that that is what Chachu was drawing attention to. In a 50-50 situation, in the issue that judge, excuse me, in the 50-50 situation, that judge will fall back into where he is. And it may be a situation, even not on political grounds. We have some judges we claim
I think we can deal with this quickly so that my other guests can come in. I'm asking, the judgment in totality, Justice Eni Yeboah is one of those who unanimously voted to dismiss duplicate serial numbers, duplicate polling station codes, and unknown polling stations. Is that correct?
Yes, that is very correct.
Okay, that doesn't sound like consistently against the respondents.
No, certainly not. But I'm saying that that is also again taking a literalist view of what Chachu said. But Chachu was speaking in context. You see, and I was telling you that we were convinced, and we dissuaded our supporters, millions of supporters, from the position that we had, quote, a hostile bench, because we believed in our case, because we believed that the petition didn't have a good case. You understand? And
another analysis on this case, 7th February, whilst the case was going on, 7th February, the petitioners make an application. And the application is dismissed. This was an application to produce documents for inspection and to make copies. Those who dismissed it included Justice Eni Yeboah. That's not consistently voting against the respondents.
I'm sorry, but I'm saying that Chachu was raising an academic argument. It wasn't a one-on-one factual thing. It was a debate. I mean, it was having an interview. He granted an interview.
Let me just finish this. Let me just finish this, and then you finish your point. You are familiar with the case of Ransford France versus the Electoral Commission and Attorney General, which judgment came on the 19th of October, 2012. Right. Justice Eni Yeboah was on that bench and you know the results.
Yeah.
Number 3, you just wait. Number 3, there was this James Amate versus Electoral Commission of Ghana and the Honorable Attorney General. That case too did not succeed against the government. This one judgment was given on the 24th of October, 2012. I'll give you 2 more. The Center for Public Interest Law versus Attorney General, obviously against the government. Justice Aniyebwa was on it, and it was favorable towards the government. The very final one, Bafo Sayakoto versus the Attorney General. Justice Aniyebwa was on it, and it was favorable towards the government.
Yeah.
I just want your comment.
What?
I just want your comment.
So what? I've read to you this learned treatise, which tells you clearly, and I'm saying it factually, I have been involved in government, you know, as government appoints judges. Same as must have happened in the time of...
and Justice Aniyebwa was appointed by the Kufuor administration.
Yes, I'm saying that...
And the cases I have mentioned to you were against the NDC administration.
But that is because you didn't allow me to land.
Okay, finish.
One of the points that you must understand is that if you appoint a judge, it doesn't necessarily mean that he will vote always for you. Indeed, there's a Justice Brandes in the same book. Great Justice Brandes, one of the greatest. He was called a people's lawyer in the U.S. And it was real hell to get him through to be appointed a judge. And the president literally bullied his way, the president, to get him appointed, Wilson. Listen to this. At the end of the day, ironically, despite his convictions regarding the quote curse of beginners, Justice Brandes never wrote an opinion in favor of the government in an antitrust case.
Interesting.
Listen, secondly, I will come back to Ghana. Mr. Justice Ekins, may he rest in peace, died this year. He was the Attorney General in the PNDC era. He was part of the government of PNDC. When the issue of celebrating the PNDC 31st December came up, he wrote a lead judgment. He nailed that with the celebration here.
You're right.
So I just want to tell you that, you know, what Chachu said must be put in context. For me as a lawyer, understand it. I'm sure that Mr. Justice Aniyebwa understand where Chachu is coming from. Unfortunately, the perception is that he's attacking an individual. Okay. And then secondly, as I've said, I mean, maybe if it were a reflection many months after the event, we wouldn't be taking Chachu to the cleaners as the way we do it. But otherwise, I can give you a list of judges who were appointed by government, including somebody, Bannerman, who was brought from Zambia or somewhere there, you know, immediately after state school, and appointed a chief justice when he wasn't even a Supreme Court judge. Okay. I mean, way down there.
I'll return to you.
A deputy attorney general who was appointed, what do you call it, a Supreme Court judge.
I'll return to you. I'll return to you and have you answer the last question on this for me.
Yes.
That whether you think the forum Chachu chose is right, knowing that the judges, by their judicial oath, cannot respond publicly, and that there's a channel that you can activate to do such things, make such accusations in the system. Now, Gabi.
Oh, well. I thought you would respond and we end it.
No, I'll come to you. I want you to think about that one. Yes, Gabi. Yes.
First of all, I think we shouldn't read too much into the political ideologies, even if we know of judges. Was it Eisenhower? President Eisenhower, he was asked after he left the presidency whether there are any things that he regrets. And he said there are 2, and they are both sitting at the Supreme Court.
Oh, I see.
Yes. He appointed Warren and I think John Brennan. And Warren was a former California governor and actually a vice presidential nominee of the Republican Party in 1948. And the Warren Court was the court that saw to, if like, the dismantling of segregation, you know, Brown and Board of Education and all those. You know, so, and even the concept of one man, one vote. So really, he thought he was appointing, if you like, conservative judges And that court, the Warren Court, ended up being the most liberal court and started this whole process of if you like, equality against segregation and the rest of it. So that it is not always right to say so. Having said that, justices, they vote. You know, they do vote. So if they vote, they will have preferences. They may be even floating voters here. I've heard reliably that then Mr. William Matuguba filed as a parliamentary candidate of the MPP in 1992. William Matuguba, who is now Justice William Matuguba.
Yes.
Okay, was an MPP parliamentary candidate, I believe, for Bogatanga.
Yeah.
And then 96, helped by the then Chief of Staff, they picked him and sent him straight to the Supreme Court.
But you think that's a fair statement to say?
Helped by the Chief of Staff.
That's held by him, they picked him and sent him there.
But is the president nominates?
No, I want to say,
I'm not saying,
I want to suggest that it was not on merit.
Oh, I didn't say it wasn't on merit.
All right.
I would never say that.
Okay.
But I'm saying that, of course, Chief of Staff helps the president to look at, if you like, talents. And he will admit it, that he played a role in getting him to the bench. You know, and in fact,
I don't know what you're talking about.
Just looking at this case. Just looking at this case.
That's not true.
And getting him to which of the benches are you talking about?
He went straight to the Supreme Court.
Straight to the Supreme Court?
Yes.
Okay.
He was never, I don't think he was ever a judge at the High Court. Private lawyer, and then he became prosecutor, I believe, state attorney or so. And then from there he went straight to the Supreme Court.
And again, going straight to the Supreme Court is not wrong. It's perfectly, it happens.
I never said that. I'm just saying. You know, his background, at least in 92.
But I need to correct this.
Yeah.
That I cannot confirm that I was instrumental in getting.
It wouldn't be bad if you were. If you are not, I'm not stating it as a. No, I get your point.
That I was instrumental in getting him there.
Right.
I would have been part of the processing the documentation because that was my job.
Okay.
Yes.
That's fine.
Okay.
That's fine. But I'm not saying it as a negative.
Yeah.
But I'm saying, so by even going by this judgment, would you say that Justice Atuguba showed some political bias to the MPP or the petitioners? I doubt that very much. You know, so I find it difficult to...
Or for the MPP, because he was a candidate.
I said for the MPP.
Okay.
I didn't say for the NDC.
Okay.
I will reserve my comments on that. You know, so I think really we shouldn't read too much into that.
I've heard many MPP leaders and communicators. They've been very blunt about it, that indeed Justice Atuguba ought to be accused of consistently being biased against them.
I mean, they're allowed to have their opinion. Yeah. I mean, that's their opinion. I mean, yes, and they're entitled to it. I'm not going to take it away from them. And I'm sure they can show voting patterns to support that. But that's their opinion.
And you agree to that sort of analysis?
Agree to... why do you have to accept somebody's analysis? I'm not here to accept anybody's analysis. I'm here to make my own analysis. So let me get to my analysis. Let me get to my analysis. I think Mr. Chikata's point actually inures to the benefit of President Kufuor. Because going by that logic, then it appears that he did an Eisenhower. He voted, he brought people to the Supreme Court that he thought they were for his party. Because 6 of his appointees, in terms of the 6 categories of infractions, okay, all of them did not find in favor, none of them find totally in favor of the petitioners. So you would say there are 3 who found 3 in favor of the petitioners. So you could say that at least them, they're neutral. They are not party political. Then, of course, there's one who found 2 for the petitioners and 4 not for the petitioners. And there's one who found 5 not for the petitioners and 1 for the petitioners. And then you go to the other side. You will find the other side, the majority, perhaps. I'm not too sure even if they're the majority, but we'll get into that later. You get to the other side. You have NDC appointees, Justice Atuguba. He found all 6 against the petitioners.
No, I think it's the need for correction. They were not NDC appointees. They could have been persons who were appointed
by the government.
Yes.
Okay, I accept the correction. Yes. I accept it.
They are not.
Persons appointed by a president who happened to be NDC. Is that fair?
Yes, in line with your argument.
Okay.
They wouldn't necessarily vote for the NDC.
Okay.
That's your argument.
No, I'm not making that. I'm just making my analysis.
Go ahead.
Okay?
He's only correcting it.
No, you're allowed to correct my analysis, of course. There what? 3 of them? Justice Atuguba, Justice Badegbe, Justice Vida Akoto-Banfo. All 3 of them found absolutely no merit in the case of the petitioners. So going by that logic, then it appears that President Kufuor's appointees were rather more objective than NDC president's appointees. But we don't want to spend too much time on that. Mr. Chikata is an experienced lawyer. He has said things that even the President of the Republic appears not to be happy with it. It's unfortunate, if you like, that after this court case, that has been the major issue.
And your party is accused of doing what it criticizes or condemns Chachu for doing.
Which
because after the statement by Chachu Chikata, after the accusation by Chachu Chikata, you would find a consistent, you know, as if it were a policy for communication about the verdicts.
Oh, I see.
Yes.
So he sort of opened the floodgates. Is that what you're trying to tell me?
Does that guarantee, if you say it's wrong, does that guarantee continuing the wrong?
I'm asking you, and I think we are both being rhetorical here. You know, you are asking questions, I'm asking questions. You said after he said that, he sort of opened the floodgates. You know, we have this political environment of tit for tat, whichever way you look at it. It is there. You know, in terms of even my little thing I said.
Little.
We'll get to that. We'll get to that. There are those who think you are now seeking to rationalize.
I'm just saying.
So you finish. We'll get
my little thing I said was used to what? Somehow, is it equalize what Mr. Chikata said. So you know, you have this sort of tit for tat politics that we have. But clearly, I don't think it did any favors to his case. I mean, was it H.K. Premper who wrote? He said, it's bad enough being a sore loser, but to be a sore winner, it creates the impression that you don't even believe you won. Anyway, that's fine.
All right.
I'm surprised. You know, the examples Nana Tudaisi gave relative to Justice Akins and what he did in the course of the 31st December case is what nails Chachu completely. That's what makes what Mr. Chikata said terminally unsustainable, inexcusable.
Terminally?
Unsustainable. Completely inexcusable. Such a deficit in logic and any statistical analysis of the issue he was raising. Look, it's legitimate to discuss what he calls lack of judicial balance or judicial partiality or bias. These are legitimate issues that can be raised and discussed. And indeed, our history has examples of such issues having come up over the years, in many cases. So that is not the issue.
So people are saying, what is the problem? Because, for example, if you go to America, lawyers study a certain jurisprudence to predict what the Supreme Court will do before they go there. And they are looking at their ideological...
That's why I'm saying in principle, there's nothing wrong to raise an issue of judicial balance or lack of judicial balance or judicial partiality and discuss it. And if you want to single out judges within that context, then you come with something of evidential value to prove your point, or you risk scandalizing them beyond repair. So you have the right to raise the issue, and you have the right to even target a particular judge or justices and say they are guilty of lack of judicial balance. But in so doing, you must give us evidence to that effect. Otherwise, it's wrong. And I'm being charitable saying it's wrong. I'm looking for a harsher way of describing it. Now let's look. You may.
Don't provide the word.
Now let's be specific.
Yeah.
That's how you look at it. When it comes to these issues, you look at each issue on its own merit. Otherwise, generalization won't help anybody.
All right.
Now, what is it that Mr. Chikata was talking about? He singles out Justice Eni Yabua for what he claims to be lack of judicial balance on his part. Indeed, he didn't restrict himself to just this presidential election petition. Within the context of the presidential election petition, obviously, he got his mathematics and statistics wrong. And I won't waste my time belaboring that point. You have proved some here. So, in that key sense, he's wrong. Now, he went for a case that he was involved in, the IFC immunity thing, and said that decision, and it was a court of appeal, so it wasn't only Eni Yabua, I suppose so.
But he wrote the lead judgment.
It doesn't matter. There were three of them there.
He wrote the judgment.
Yes,
so
yes, but there were three. I mean, as far as I'm concerned, I don't know, but there were three. I haven't checked those others, but I know for sure there would have been three. He goes for that case and talks about the fact that the man went quoting or referring to an IMF statute instead of an IFC one, and to that extent ruled that IFC had immunity and could not be compelled as a witness for Tasu Chikata. Is that not the issue?
That is so.
That could be a fundamental error of law on the part of a judge. You could analyze that, and that's why we have the appellate structure, and deal with it in a very legal manner to show why a particular, and Justice Eni Yabua in his Court of Appeal, that panel, would not have been the first Court of Appeal panel to have committed an error that was subsequently cured by the Supreme Court. So if it is a legitimate case of an error of law that you are dealing with, deal with it. He sought to link that particular judgment and Eni Yabua's role to what he claimed to be the consistency of his voting pattern in this particular case. First of all, we've seen that there is a certain disjoint. It's not true that he could link the two. Then when you go for the Eni Yabua, the IFC thing, where is the politics? He linked that to what he claimed to be political loyalty based on the source of appointment. All what we are discussing here about ideological and political orientations of judges in the US and the rest, that's not coming to this statute thing. He's made a specific case. The specific case being that this particular judge, in erring, if you like, on the IFC immunity thing, did so because of who appointed him. He should be put to strict proof to deal with that issue, to convince us. He hasn't been able to convince us. And we have people rationalizing that and trying to bring it within the broader context of, yes, we can discuss judges in terms of their general political, ideological orientation. That's an escapist route. We shouldn't allow that to happen. That's a cowardly route to take. People are running away from responsibility. In any case, when that case went to the Supreme Court, it was dismissed in part. Or would you say upheld in part? In the sense that the Supreme Court said that the IFC as a corporate entity had no immunity, but its directors had immunity. So really, and it was 3-2. Incidentally, those who voted 3, the majority was Sophia Kufu, Sophia Adinira, and Julius Ansan. 2 of them are in this panel. Those in the minority was Atuba and Vida Akoto Banfu. They are also on this panel. How do you connect the two? Am I to go for the absurdity and suggest that those who voted in his favor are people linked to him or his party? You see, there's no sense in it. Please, let's not for one moment rationalize what he did. It's a gaffe. of gargantuan proportion, inexcusable, no basis for anybody.
These words from Google.
You? Look, let's be honest. It's a gaffe.
Oh.
Forget the timing and everything, which itself was serious. The essence, the substance of what a great legal mind like Mr. Chikata put out there is not something we should come and sit here and rationalize. We cannot.
Well,
and we dare not.
Nana, now this one,
Yes,
in a minute, can you tell me, the question is also coming up about the choice of the forum. If you think he didn't do anything wrong, was it right to use that forum, knowing the judge cannot answer in that forum?
I just want to say in a moment, but I don't like the way you have introduced the judge into that forum. You understand? Even though Mr. Chekata raised it, I remember Kweku said that this after judgment embargo that people are seeking to enforce should not entertain it. This is a democratic state. You understand? Whether it is an interview or whatever, if what according to him, what he is not comfortable with it, as another matter. But I don't think that we should limit it to the fact that it was an interview. It could have been an interview. It could have been a critique. In fact, it's going to happen at the law school. Law school for the next 150 years. They will be analyzing each single judgment, and some may be more uncharitable than some what others are saying. You understand? Once a judge writes his judgment, he's out. You understand? He cannot stop people from criticizing. I have said, and I want to be on record as saying that whenever you put a man on a Supreme Court, he ceases to be your friend. And I'm sure of that. That's what Harry Truman says.
All right.
And then the other guys, it's not from a book, you know.
No, I thought that was a perfect quote on which we can move on to Gabi's statement.
So, but just, if you permit me, but Kweku's point, I take part of it in good faith, and that the mix of voting of the judges will really undermine anybody who will also say that the so-called other side,
Right,
voted because they were appointed by NDC.
I agree.
You agree with that?
I agree with you.
So now we should come back to the substance.
Great.
And I think that is a better platform than arguing this individual case.
Critically
We'll
scrutinizing
come
what
to
Mr.
Gabi's point
Chikata
too.
said.
Great.
What is-
Now, Gabi,
Now what were you saying?
you said, unlike Chachu, you say your focus was on the judgment and not on the judges. And you said it was a corrupt judgment.
Yeah.
Victory.
Yes. That's what I said. Now, first of all, there's no question in my mind, and I believe in all Ghanaians, perhaps, that the Supreme Court has declared, and that declaration holds. I personally listened to Akufo-Addo yesterday, repeating that they are not going for review. So let's just get that out of the way. Any critique of the decision is not to if you like, challenge the validity of the president's election, because that is done. Whatever we are doing here, as far as I'm concerned, is academic. But it may also be useful for future decisions, because, I mean, I'll be very surprised if in future cases it is the majority decision that will be upheld. But that's neither here nor there. Yes, I said the decision was corrupt, and I still think that the majority decision is a corrupt one. Corrupt in a sense that when there's an entrenched constitutional provision, and the Supreme Court is the body that the Constitution has said that, look, you protect the Constitution. Make sure that we all adhere to the Constitution. And then when it comes to a matter of interpretation or giving force to an entrenched, clear constitutional provision, then you have Supreme Court justices going beyond that clear wording to go and seek refuge in like a case in Canada, Opitz, which was a challenge between an act of parliament against a constitutional provision, a charter, and then they uphold the charter, then you go and seek refuge there and find all manner of words to downplay the constitutional provision. I think it's a corruption of the Constitution, and it's a dangerous route for a Supreme Court to take. And I'm I don't intend to apologize, and I don't see anything wrong with that. Beyond that, when the Supreme Court...
The question is, if you didn't see anything wrong with it,
yeah,
you appear to have been afraid that it
Me,
may not
afraid?
have been correct.
afraid. No, because I
Because you went forward to say...
I saw the comments.
You went forward to
I
say...
saw the comments.
That they could invite you.
Yes.
After all, your grandpa
Yeah.
was incarcerated for standing for his
I
convictions.
said he died in jail.
In
for his
jail
convictions.
for
Yeah.
standing for his convictions.
So, no, because people, I mean, I had phone calls from even well-wishers. Hey, Gabby, they will call you. I mean, you know, and I'm thinking, really? So, what is the big deal? What is the worst thing they can do to me? I will go there and defend myself. If they think that it is such a major issue for them, what's the worst thing they can do to me? Throw me into jail? Or what? Say I'm no longer a lawyer? And I'm saying that my own grandpa died in jail for his conviction? He wasn't able to practice again? So what is it that they can do to me?
That there is an expectation that
No, I mean-
you as a lawyer,
But I'm saying,
must be aware
I'm
of the
saying-
limits.
I don't think that I've gone anywhere near the limit. Let them come and take me, if that's how they feel. That they're beyond criticism. And look, even the presiding judge accuses, effectively, 4 of his own colleagues, brothers and sisters, of endorsing something that was fraudulent. Justice William Atuguba, in the judgment, accuses his own brothers and sisters of endorsing something that is fraudulent. I'm just saying.
I want to put in perspective that you are seeking to say he accused them, but he didn't accuse them. Let me read a statement. Let me read it. He says, in this case, it would be unfair and fraudulent for the petitioners to authenticate the results through their polling agent signatures and turn around to seek to invalidate on the purely technical ground of absence of presiding officer's signature.
Absolutely.
That is not an accusation.
No, I said effectively.
Now,
Let me explain it to you. What he said will be fraudulent. 4 of his own colleagues endorsed. So what does that mean? So they have what? Endorsed something that is fraudulent? Petitioners come to court to enforce a constitutional provision, and you, the presiding judge, can accuse them of a fraudulent act.
Hold on.
Please. I mean, if
Alex,
you want
let me hear you on this. Let me hear you on this.
I think that Gabi is treading on dangerous waters.
Really? Let
He's
me
my brother.
tread
on it. He's my brother.
Yeah, but leave me to tread on it.
You will. Okay.
And let them deal with me.
But
that's how it will work in this country.
I don't have a problem.
That we don't have a freedom of expression in this country. If I see something wrong, I cannot say it and say it in the harshest tone that I can.
Okay, Gabi, sorry, your point is
Without
made.
necessarily taking any charge.
Your point is made. Let's hear him.
You see, when you started with the first element, what was my initial statement? I said it depends on the hat you wear when you want to look at these issues. Any person who is on the NDC side listening to Gabi will ask the first question, why is anybody talking about Chachu's matter? Because in the same way, the critique, if I was to follow Kweku Baku's critique, I don't understand where Gabi is coming from. Why do I say that? The first statement Gabi said was that this judgment is corrupt. At the time when he made the statement, he didn't explain what he meant.
I did.
Well, if you
it's
did...
on Facebook, I did. Please.
Well, listen, it was made in the studio, wasn't it?
No, I made it in Facebook.
Okay, okay.
I'm telling you, I did. So, don't say
now,
it was on Facebook, and then it was picked, and a story was done out of it.
Okay,
online.
I stand corrected. When Gabi made the statement about it being corrupt, or we heard it, one, it would have been better for Gabi to have qualified it properly. Because when you say a judgment is corrupt, when there were actually potentially 6 judgments in one, you are actually saying that the whole thing. Now, based on even his example that he gives now, where he singles out one aspect, which is signature of presiding officers, as the aspect which, what he's saying is that 4 of the judges who decided that it was fundamental are correct, but the other 5 are corrupt. The reason why I have a problem with Gabi's language is that corrupt is a criminal term. It is not
like fraudulent.
Exactly. It is a criminal term.
He's saying he's using it
it
against the judges. But he's using it if
5 judges made a decision.
He's saying
which he does not agree with.
In terms
and he says
of,
it is corrupt.
If you can hear me, just a line. Yes. He's saying that I am saying there is a corruption of the Constitution. The Constitution has a mandatory provision.
He didn't say that. He said there's a corruption of the judgment. Don't say that. It's not a corruption of the Constitution.
His explanation gives me that understanding.
Well, the point is that, for me, it is a change. He's moving his goalposts. He is moving his goalposts.
If you had followed my Facebook, you would know that I haven't.
Well, this is my view.
Well, but you haven't been following it, so you can't say that I'm shifting the goalpost.
He's not alone in that. Let him make his point.
Okay. But I shouldn't say I'm shifting the goalpost.
The word corrupt that you used
was,
for me, fundamentally flawed.
And the explanation is an afterthought.
And the explanation is, for me, it doesn't even help issues. But that is Gabi, and that is why I'm saying, if you put on a political hat, I can see where he's coming from, and I know his people some people even defend him and say, well, this, that, and that, because they are putting on a political hat. But if you put on your patriotic hat, you have to say that the statement was unfortunate. It is not a statement that should have been made. It put the whole judiciary into disrepute. I could use exactly the same harsh words that Kweku has just used. So I'm going to listen to his rendition and see how he's going to do political gymnastics in this one or not. As to, well, yes, because I actually don't see even the word that he used, for me, is more damning, excuse me to say, than bias, which is what people are inferring from Chachu's, statement, that the judge had certain biases because of where he was appointed, blah, blah, blah. But to say that it was corrupt, for me, if a judge is saying that petitioners, people who have come before him, he feels that it was a fraudulent act, that is the judge's prerogative. He can say that. But he's not accusing. I don't have an opinion. He's not accusing this thing. But you are saying that they are fraudulent.
He's asking you a question. Why can he?
I don't have an opinion.
Why can he, who has an equal stake,
so does he agree,
who has an equal stake in the Republic,
so can I ask you,
who enjoys the same rights as the judge?
This is why. No, Samson, you remember, and I was giving my rendition. I said, if the people who made the first allegation against the judge apologize or accept that they did something wrong, if Gabi accepts that they did something wrong, then it is rational to say to Chachu, yes, maybe you also did something wrong. All of you. But if you have everybody standing on their marks, because all that is happening is that people are putting on political hats.
Right.
And if that is the position, yes, it is.
Well, okay, so,
and if you have done that, then for me, you
Alex.
cannot criticize. He has no basis for criticizing. The only reason why, for example,
thank you, Alex. Alex, I'm just hoping that you are not corrupting Judge Gabi's comments. Now we take a break here. We take a break here.
My iPad is correct.
We take a break here, and when we return, I'll have Kweku Baako speak to this matter. I haven't spoken to you. Yes, I'll have Kweku Baako speak to this matter, and my question is, can Gabi's comments be justified, knowing he had not the benefit of the judgment at the time?
Exactly.
We'll be right back.
Oh, of course.
Thank you very much for staying with us. This is Newsfile on Joy 99.7 FM. We're coming to you live from the Multi-TV studios. This is your Joy News channel. 1422 is the text line. You can send us your comments, and you can post them on our Facebook wall as well. And you can also send them to newsfile@myjoyonline.com. Now, Kweku, my question that I put to you, and I must acknowledge that there are loads of comments saying that you appear to have done quite good research in the submissions you are making.
As always.
And again, there are those who say, and if you like, let me just read one of them. It says, the elderly in this country should be very careful of their posture, demeanor, and positions on political issues in this country. Gradually, they are losing their influence on we, the youth. And I wonder what it will come to when such influence is totally lost. There are suggestions that
upon the spectacles they are wearing.
there are suggestions that some of you are just going round and round and not sticking to it.
Exactly.
Now, Kuku, let's hear.
Quick one. With regards to the IFC thing I was talking about, the other two justices whose names I couldn't readily recollect, Ketsi Esankoma, I realized they are S.E. Kanyoki,
Right.
and F. Kusi Apia.
Right.
They were the two other judges. And then Gabi made a certain interesting point about Mr. Tugoba. I don't go for it in a mischievous way, but the facts, there is this list of judges and magistrates. As at May 2009, William A. Atugoba, that is date of enrollment, was 3rd October 1974.
As a magistrate.
Yes, date of first appointment to the bench, 30th November 1995.
Great.
Date of present appointment, then May 2009, was 30th November 1995.
Great.
And on that time, it was 13 years. What it means is that what Gabi said was right. Because you see, date of first appointment to the bench was 30th November 1995.
Okay. Where I had a problem was that he said he was straight to the Supreme Court. But
Yeah, but what I find
sort of knew
significant
that he had been a magistrate.
Yeah, but watch. Yeah. Of course, that is clear. But watch this one. It says date of present appointment. Present appointment as at May 2009 was the Supreme Court, as it is today.
All right.
And it's the same date.
Okay. Oh, I see. Great.
Yeah, I mean the
Great.
bench.
Great.
The people,
And
Okay.
the final one,
But there's a magistrate's court bench. So.
Mr. Segwefia made a point about in Chatru's case, there was some noise about the conviction, and that there was this talk about natural justice having been violated. Well, to put it on record, that matter went before the Supreme Court. Mr. Cheketa, if you recall, filed an application for the Supreme Court to quash his conviction. And the issue of the purported violation of his human rights, as well as the lack of natural justice, came up, and he lost. The Supreme Court, October 16, 2008, they gave the reasons 24th October 2008 to the effect that based on the records of proceedings at the trial court up to their level, there had been no violation of his fundamental human rights, and that there had been no violation of natural justice.
Right.
This particular decision stands unchallenged as we speak.
Thank you.
It stands unchallenged as we speak.
Yeah, if we can move on. You see, this
Now
issue
let's
has come
move
up
on to
over
that.
again,
Yes.
over and again.
These are records. I have the judgment
in
here
our
anyways.
political
Yeah.
discourse in this country.
He is giving the impression that I said something which I didn't.
Oh, you did.
Or, no, what I said was that judgments have been made which have been criticized. And I gave as an example that whether or not it was in favor or against or whatever, I said that even our political party had been critical of that judgment and the judge at the time.
Thank you.
So
I'm not making
the natural justice was missing. And I'm saying that issue came before the Supreme Court.
Okay. He's
And
saying they
on record,
criticized that.
The Supreme Court did not uphold the issue.
Great. Let's go.
Now to Gabi. I've had my chat with him already. There's no way I can defend Gabi's write-up. First of all, the choice of word. He's explained about it being corruption of the constitutional provision and everything. I think that Gabi was indiscreet, imprudent, and it cannot be sustained. He's explained himself. But my view, in my candid view, and the very moment I saw that thing on Facebook, indeed, I didn't see it on his page. I saw it somewhere. I commented on them and made my position clear that what had been put out by Gabi, if indeed was true, was something one cannot defend and sustain. The timing was bad. The choice of the word corrupt was also bad. I stand at the risk of being hypocritical here. I described the Mona judgment, particularly relative to the public holiday side, as devoid of common sense. And I was told I was being very harsh. So I shouldn't be somebody who should be taking on Gabi. There's that risk of being hypocritical. But I think the choice of word and the timing, and because of where he comes from, where he's positioned, I believe Gabi should have exercised some greater level of circumspection in how he described the judgment. That's my candid opinion. It cannot be sustained.
Thank you, Nana. You have a very last one on
yes,
this.
well, just a quick one. I think that Gabi has tried to dilute or corrupt the word he used, the word corrupt.
In fact,
in terms of his...
In fact, he didn't only use corrupt, but he said
farcical.
Yeah.
That is the point I'm coming to. You see, he can dilute the corrupt, but what about farcical? Farcical has a very clear meaning. You know, what the judges sat down doing was no joke. It wasn't a farce. You can't say that that's a farcical act. Indeed, you have 9 judges, and I'm saying that I suspect that Gabi must have come to this conclusion rather too early, because he probably didn't have advantage of reading the judgment in detail.
It's actually it's confirmed my position.
Yeah, okay. No, okay. If no, listen, I'll move on to the next point. That if, after reading the judgment, he still stands by his conclusion that the judgment or the totality of it was corrupt and farcical, then I'll borrow the Koku's words, that there's a deficit not only in logic but in legal knowledge. Honestly. Because
that's your opinion.
Oh, no, that's absolutely. Because I had a certain opinion about this judgment myself. I've spent some time reading each and every single judgment, and I'm impressed by the amount of work the 9 judges put in. Look, they differed, but they differed on legal grounds. One group was following a literalist view. The other group was following the modern purposive approach.
We'll get into that,
yeah,
but you may not be correct, because they are not saying they followed literalist view.
No, they don't need to.
In fact, some of the members of the majority proclaim that they are following a purposive, benevolent, broad approach.
Yes,
but some say that rather appears to be the other way.
Yeah, but I'm saying that you could see that at least whatever it is, they were following clear legal principles in coming to their conclusion.
All right.
And that Gabi cannot take away from them. I think that they did a good job. They did a good job. They disagreed. That's why they were expected to. They are expected to be 9. You know, and as far as I'm concerned, where they agreed, 90, 90, 90, there was nothing they could do about it. But when it comes, I was talking about the 50-50 situation, they take position depending upon their upbringing, their outlook, and all that.
Thank you.
And I think that
it's
unfair to them.
Thank you very much. Now let me read some of the messages that you are sending in. Yemu from Kumbungu writes, "We Ghanaians must praise Nana Addo for accepting the judgment without having the benefit of the reasons given by the justices. If Nana Addo were a violent leader as perceived by the NDC propagandists, he would have used this verdict to destabilize the country. God bless Ghana. God bless Nana Addo." Gabi Ameyanu.
That's his name.
He says the most honorable thing for Chachu to do now is to apologize, unreservedly to the nation and stop the. You are saying he's arrogant. We have had enough. Ajiman, right from Amsterdam, he says the Supreme Court in the beginning of the petition set out the path it was going to take. That is, we know them, and he says that. Since they didn't follow them, why is it that they did not follow them? Okay. They need to justify that as far as you are concerned. Now, let me move on to the next message that I have that is coming in. Bonti Benjamin says it is very sad that Mr. Alex Segwefia is trying to score political equalization with the most unfortunate sentiment made by Mr. Chiketa. He should please note attacking the personality of a judge is not the same as attacking the judgment of the court, which is subject to scrutiny. Awal Abdullahi Samson, as a growing democratic nation, we all need to avoid the tendency to tag our judges as being political and corrupt in their judgment. in order not to put the name of the judiciary into disrepute, for that is the only institution that still holds the nation together. Thank you very much for your messages. Keep them coming in. And we now get into the details of 155, depending on which one you have. And I said 100, 588. Where did that one come from? 588 page or 607 or so, depending on which one you are holding. First of all, I think I'd like to start with you, Alex. The judgments, reading through, we cannot go through them one by one.
I'll deal with it as a whole.
Okay.
I'm not going to go into specifics.
I was thinking if we could do this way, it might be most helpful. That your general impression in a minute of the entire judgments, and then we move to deal with them on the vexed matters. Justice Atuga says the matter that devastated the courts over voting. And then he comes to deal with the matters of absence of presiding officer's signature.
The very one that he said was
said that matter devastated the court, got the court so divided.
Devastated the court.
Right. So that we can hear you a minute on the general thing, and then we'll take time to look at overvoting, voting without biometric, and presiding officer, absence of presiding officer's signatures.
Okay. First and foremost, I would say that tactically, I don't think that the petitioners did themselves any favor. It's a very difficult judgment call to make when you're going into a trial. But I think they were influenced by the need to demonstrate, because of the court of public opinion that also exists, demonstrate a very large case against the respondents. And therefore actually made the judgment call of throwing everything at the respondents, including the kitchen sink. Had they been more cogent about their case and dealt with really what they thought was wrong and left out this duplicate serial numbers and polling stations not known, etc., which was a cause of a lot of commentary, so that they even lost the battle in the court of public opinion because people harped upon that.
That's what you think?
This is my opinion. I'm just, They may have had a better hearing on the issues that existed. But that is
more than 5-4.
Well, no, I'm just saying that they would have heard, the cases would have been more crystal. We wouldn't have spent 8 months for a start. And they would have got their case better prepared, because even in the judgments, you hear comments of, look, the way this exhibit list and things were going, it was clear that the case was not even brought properly before us. I mean, that is one of the judges makes, at least one, makes commentary on the way the case was presented. And it was partially because of trying to throw everything, when actually, for me, tactically, it was a bad tactical move. But that is my humble opinion.
Start with absence of presiding officer's signatures.
I think that, for me, if you go with the minority position, you can really end up with a situation of absurdity. And why do I say that? If you look at section 49 and
Article 49,
Article 49
clause
of the
3.
Yes. In that very same section, the need for polling agents to sign is there. Now, there is a debate on how you wish to interpret language.
You're getting at it. When you get there, read it before you continue.
Okay. Article 49 says, very quickly, the presiding officer, comma, the candidates or their representatives, comma, or should I say, it stops there because the next one is end. In the case of a referendum. So everything that comes after that is in the case of a referendum. It says, the parties contesting or their agents and the polling agents, if any, shall then sign a declaration stating the polling station, the number of votes cast in favor of each candidate or question. And the presiding officer shall then announce the results, blah, blah, before communicating them to the returning officer. There is a mandatory requirement as high on the polling agents, on the presiding officer, as is on the polling agents.
Okay, and again, we are not asking for your interpretation of this provision.
Yeah.
We're asking you to look at it from the judgment.
Yes. But the reason why I put the comments in is there's a judgment by one of the yes, who makes it clear that, look,
does she make it clear?
For me,
okay.
That, look, when you interpret that clause, actually, it's a mandatory, the shall is not, because one of the minority decisions seems to, or the petitioner's view, as hitherto put in, seems to give the impression that it's not a mandatory requirement for polling agents. It is only for presiding officers. I disagree. I think that the polling agents also have a mandatory right to sign. Now,
he qualified that.
Yeah, you can't. Well, the reason why now I'm moving slightly away from the judgment is that, think about it logically. And this is the argument that has been put, and people try to rubbish it, but it's not a rubbish argument. If polling agents should sign, shall is the word, it applies to them because the polling agents are the representatives of the candidates at the, what's it called? Polling agents, the polling station. What are we going to go through every pink sheet and say that because this particular agent didn't sign, even if the person is from an independent candidate or what's it called, a party that doesn't have a lot of votes, and the person halfway through decides, look, when they started counting, he knows that he has got only 3 or 4 votes, and he walks away. He was present, even if you want to go by the second name, and it hasn't signed. Are we going to annul votes? Are you seriously saying that with the kind of political history that we have, if any political party decides to tell its agents in one region or another, be there when it's over, don't sign, just collect your pink sheet and go, and then you go into court and say, well, they didn't sign, because the minority have gone on the strict interpretation of the letter of the law of the Constitution, and the majority is saying that no. Look at the whole gamut of that section and see what it is trying, what mischief or what intent it has. And don't interpret it in a manner that can create an absurd situation. That is what you call the purposive approach.
How about those, the minority, who say this is not only a mandatory injunction on the people, but this particular provision is an entrenched clause of the Constitution?
There are many conflicting entrenched clauses of the what's it called within our Constitution. If you go through it, there are areas which conflict. Unfortunately, I don't have the authorities here to hand, but there are areas.
So
and
which area does this conflict with?
Which
other entrenched provision does this one conflict?
The right to have your vote, and have your vote counted.
Article 42.
Yes,
it is.
42.
It is a conflict.
Yes,
Article 42. Within Article 42.
Okay. And I'm going to keep you guys to time strictly so that we can exhaust the arguments.
Article 42 gives every Ghanaian who is of sound age and of mind the right to vote and technically to have his vote counted. And I'm saying that is the overarching, is the first, Article 42 is the first article under the voting process. That is a fundamental human right. Enshrined. It goes, I think the same judge that goes through the human rights, adult suffrage, etc., etc. It's gone through in detail. So that fundamental human right, for me, is in conflict technically with Article 49.3. Because if you interpret it strictly, by virtue of one person's lack of signature, which you are saying is entrenched, my vote can be annulled. When in actual fact, it has no bearing on the numbers or the figures that occurred. It means that the whole process can be squeaky clean, completely clean. And one person decides he will not sign, and therefore all our votes should be annulled. I find that going towards absurdity. And that is why, to a certain reason, when the judge uses the word fraudulent, I can understand it. Because you can actually put a presiding officer in a position where he can hold a whole polling station to ransom. And for that matter, it doesn't stop there. The reason why it becomes absurd is that if you follow that, any polling agent, don't forget the presiding officer,
any polling agent can also decide, I will not sign.
Okay, hold on there. Gabi,
Yeah.
you support the view that is cast in terms such as failure by the presiding officer to sign the declaration form is an irregularity which cannot be excused or waived on the grounds that the pressure of time, prevailing atmospheric conditions, etc., did not simply allow or permit them to sign the forms and thereby comply with the constitutional duty. The duty cast on the presiding officer to sign the declaration was couched in mandatory terms and deserves obedience and not meant to be disobeyed. An election, much more so, presidential elections, are serious matters governed by well-laid rules to preserve sanctity and integrity of the elections, especially where a specific duty is imposed on election officials. A breach of any of those duties meant the integrity of the election was compromised and ultimately affected the exercise of the right to vote, as well as jeopardizing the sovereign will of the people. That's where you stand.
Yes. And I think Justice Animi Abua at page 471 calls Justice Atuguba in another case, where Justice Atuguba said, any act of a court that is contrary to a statute, such as Act 722, is, unless expressly or impliedly provided, a nullity. And he goes on to say, page 472, the question is, if a court of law does not give effect to the law, who will? And that's the danger. You know, let me start from Alex Segbefia's argument, which is endorsed by Justice Bafo-Bonnet. Now, on the issue of absence of presiding officer's signature, Justice Gbadegbe describes it as not rooted in shared common sense. Okay? That votes should be annulled because of absence of signature. It's not rooted in shared common sense. Those were the words he used. And when you read the reasoning of Bafo-Bonnet, which I find quite unfortunate, and I will tell you why. He goes on to say, now first of all, he made an argument which I believe the rest eventually, I mean those who said that the vote should be cancelled and rerun. And I think all of them came there because his argument, he's the only one who goes to explain why. And his argument is quite simple. He says, rather, the results may only be cancelled, i.e. where you find infractions that affect the results, as having been compromised or tainted by administrative lapses. In that case, we should not cancel the whole election, nor should the election be called based only on the remaining untainted votes, as being suggested by the petitioners. But the voters and polling stations whose votes are cancelled as a result of the administrative lapses must be given the second chance to exercise their constitutionally guaranteed right to vote before the final results are declared. Now, that in itself is a way out in terms of protecting Article 42.
Sure.
Because there's been a breach of an entrenched constitutional provision. Do you think it was for nothing that only the duties of the presiding officer and the polling agents have been put in the Constitution? Anything else in terms of how the electoral process must be run, the Electoral Commission has been given powers to go and enact, if you like, constitutional instruments and what have you, okay, in terms of how elections are conducted. It was not for nothing. And when you get to Justice Adinia's argument, let me have the Constitution, Article 49, where she tries to explain that where the if any is, the if any has to do with referendum. I think that's actually also sad, and I'll explain that to you. If you go to Article 49.2, this is what it says. There's a process, things that, like Article 181, which says that it must go to Parliament and it only comes to effect after it has been approved by Parliament.
On the basis of which Martin Amidu won the two victories. Absolutely. In respect of Isofoton and Waterloo.
And if you read Atuguba's argument, he seems to go with the Court of Appeal decision on the Faro case rather than the Supreme Court decision. Okay? Now, when you look at Article 492, it says immediately after the close of poll, there are a lot of things that you have to do, and none they have to follow consequentially, because
You can't take the pink sheets to the returning officer and now come and declare. All those things have to be done. And there's a reason for all these things that have to be done. And then she says that if any, that polling agents, because the petitioners were saying that polling agents don't have to be there. It says that it's only when they are there, and that's Julius Ansah's argument, that's Anemia Boa's argument, that's Rosa Usuan's argument, that is Doche's argument.
But if they are there, what happens?
Only when they are there that they are required to sign.
Is it a mandatory requirement?
Absolutely, when they are there. But then when you go to Regulation 44 of CI 75, it tells you that the absence of the polling agent's signature does not invalidate the results. How come it did not say expressly?
Gabi.
No, please, let me continue. That the absence of a presiding officer's signature does not invalidate the results.
Okay.
Precisely. But it tells you that, yes, if you are there, we want you to have the authority to sign if you are there. Okay? And the if any that she's talking about, that he only refers to referenda. If you look at the preceding clause, it says, immediately after the close of the poll, the presiding officer shall, in the presence of such of the candidates, all their reps and their polling agents, as are present. You get it? As are present. Isn't it the same as if any?
Yeah.
As are present.
Yeah. Correct.
So when you get to clause 3, and the Supreme Court, after reading this, a Supreme Court judge gets to clause 3 and says that the presiding officer, the candidates or their representatives, and in the case of a referendum, the parties contesting or their agents and the polling agents, if any, that if any only refers to a referendum.
But your argument is based on the purposive interpretation.
No, mine is
clause
not.
2 and clause 3 are different.
No, but I'm saying,
you cannot use clause 2 to interpret
I'm
clause
saying,
3.
clause 2 tells you that the first time in terms of the duty of the agent is referred to. And it tells you that if they are present, and then you get to clause 3, it says they should sign if any. So then, what does that happen?
The majority suggests that you may be pushing constitutionalism to a point of crushing substantial justice.
And I will say they are
wrong. And that the basis of the consideration of substantial justice must be overriding. Look at the fact that they are supposed to sign, yes, mandatorily, but they didn't sign. The polling agents have signed.
Okay.
The process was done in the full glare of the public.
Yes. Okay.
There may have been errors. Some of which were corrected at the collation center. Then a judge says, what error has been committed, we can punish the polling, the presiding officer who failed to do his duty. We can punish him for failing to do the duty. Lastly, a judge also says, why don't we call this an administrative error? And if it's an administrative error, it can be corrected without necessarily invalidating the process. You don't agree with that?
Why should I agree with it? We are dealing, look, you either respect the Constitution or you don't. You get to, let's go to Bafo Bonne's argument. He says, a corrupt politician, and that's been repeated by Lesebefia here, needs only to team up with a few hundred presiding officers in an opponent's stronghold. And bingo, fortunes are turned. This will be carrying strict interpretation to absurd limits.
No, point of order. Just point of order.
Please.
If you have been waiting patiently to make this correction, and this is the second time you are quoting Bafo Bonne, quote him correctly, you are quoting the second leg of what he said. Why don't you start from the beginning?
Why do I have to start there? This is the only thing that is relevant.
Nana, he's finishing. He's finishing in a minute.
No.
He'll be done and then you come in.
This was the argument made by your own lawyer.
Gabi, finish.
Your own lawyer.
Gabi, finish.
Okay. Relax.
Yes. No, I'm just telling you. And Sabefi has repeated it here. Now, to me, it is that reasoning that is actually absurd. Because ask yourself, it's as if the judges don't actually live in the real world. When you look, if a corrupt politician can influence a presiding officer, will that corrupt politician not have a better opportunity of influencing that presiding officer within his stronghold than in his opponent's stronghold? I mean, please, it's so commonsensical.
Thank you.
It's logical.
Thank you very much.
And,
Nana,
and for
Nana,
the judges to think.
Thank
Yeah,
you.
well,
Thank you.
Well,
First
of all,
we are dealing with presiding officer's signature.
Yes.
And first of all, a minute of your comment, or I said, a minute comment
really,
on the general
it's really
judgment.
It's really faulting. First of all, I think that there is a decision.
Yes.
And we are bound by it.
That's it.
All of us.
Well,
If it is 5-4, we are bound by
Gabi
it.
noted that on from the start.
Yes, yeah. So that's the decision, and we were going to go by. Now, secondly, I think that the issue of presiding officers not signing or not signing, raises some very fundamental conflict of rights within the Constitution itself.
All right.
Firstly, it's about the right to vote, Article 42, as my friend had said, absolutely. Then we are talking about the right to protect the vote that has been cast. You understand? Those are the two conflicting things the judges were faced with. The person has a right to vote. So what is it? There are certain things you have to ensure. Make sure that the voting thing is, he has a right to vote, it's fair, free, and all that, But when a person has also cast his vote legitimately, without he himself infringing any rule, what moral constitutional right does anyone have to exclude his vote only on account of an administrative error or problem or lapse by somebody else without his right? You are depriving him of his valid vote. Now, when my good friend Gabi keeps on quoting Bafu Bonnet, Bafu saying that Bafu Bonnet did the right thing and the most sensible thing to say that in that case there should be a rerun. I'm saying that let's get back to what Bafu Bonnet said. Justice Bafu Bonnet at page 531, he says, in relation to Article 49, he says to strictly interpret this article, and this is what Gabi didn't read. To strictly interpret this article, the way the petitioners are seeking to do is to take the importance away from the voter and giving same to the persons who run the elections. If the absence of the single signature of the presiding officer can lead to the annulment of the votes of hundreds of thousands of voters, then the election ceases to be about the voters and shifts to the presiding officer. So that if a presiding officer, either from pressure of work, oversight, or plain mischief, fails to sign, then fatally hundreds of voters are disenfranchised. Then it comes to what he read. Again, a corrupt politician needs only to so and so. You understand? So the focus for those who said that the fact that a presiding officer fails to sign should not, annul a valid vote. It's rooted in this. I'm saying that it's a conflict that must be resolved. Now, what are we talking about? We are talking about processes. And I remember Vida Akoto Bamfo, in that short judgment, made some really interesting points. That the whole process of voting, the whole thing, it's a process. It's not an event. No. So you must take everything together. One, there has been a valid vote. Nobody's complaining about it. Nobody. The votes have been cast.
They were in court.
Hold on.
Challenging the validity of
the votes have been counted in the presence of agents and whatnot. 3, the votes have been recorded by the presiding officer, the same person we are faulting. 4, the agents have signed. You get me? Eventually, and then 5, the results have been declared openly. Presiding officer fails to sign. So what? So you say you throw it all out? You say, but the Constitution says he must sign. Yeah. Now, the purpose of the agent being there, you see, and the choice of whether he should be there or not, it's left to the good sense of the candidate. It is in your own interest to make sure somebody is there. And the purpose of why the agent is there, as you know, they're under the CI 75, is to ensure the validity of the, of the process, integrity, and what they've said it. You've been advised. You've been put on notice. So if the agent is there and you're assigned, first and foremost, your interest is protected. Now, in 26,002 polling stations, the petitioner's agent signed all those documents. In 26,002 polling stations, the petitioner's agents did not complain about it. In 26,002, you know, the total of, even taking your figure, it's about just about, is it 2,000 or so polling stations where the agents didn't sign. About 2,000. Where out of 26,002, you are not complaining about the others. Secondly, when you say that there has not been a complaint at the polling station, you are raising a fundamental point. You understand? The assumption is that the vote is clean.
You know what will happen next
time?
No,
let me finish.
Let me just come in before you finish. I'll let you finish. You did that to me.
Don't throw my thought. I think I have to appeal to you to let me finish. No, let me just finish.
Okay,
I'm saying that if you follow this logic, it is absolutely clear that the pink sheet, and that's the big statement I'm going to make, that the pink sheet was wholly unnecessary. And I'll come back to it. That the whole idea of the pink sheet, if you haven't raised a complaint,
the majority have not said that the pink sheet was wholly unnecessary. In fact, they agree that it is the basic document, but it should be looked at together with. It should be looked at together with. We are looking at the judgment.
In terms of the judgment, Akoto Banfu said something. I'm saying that it doesn't matter how you see it. I'm saying Akoto Banfu in her judgment made some striking statements. You know, where she said that we go by way of pleadings in the court of law. You understand? So you raise certain matters. And if you don't plead, you can't come and raise it. Then she said also that if you look at the, particularly when you come to the biometrics and whatnot, you will find out that they all talk about the register. We are talking about register, and then we also talk about the ballot box. Now, you will find out that these two issues do not feature so much in the case of the petitioners in terms of evidence. In terms of evidence, the ballot papers were sitting down there; they were never counted. The register, the whole register,
and is the petitioner's fault?
I'm saying that was all an issue. Don't forget that, but the burden of proof is on you. So as far as I'm concerned,
but there were situations they noted that the burden of proof shifted, but you didn't.
But the point I'm saying that if you look at the process, that if you consider that it was a process, vote counted, vote recorded, vote declared, agents have signed, the literalist approach to what do you call it? To the interpretation, if I just let it, is that in modern day language, to quote the Honorable Professor Dateba, we all hold in high esteem. These days, a literal approach to statutory and constitutional interpretation is not recommended. Whilst a literal interpretation of a particular provision may, in this context, be the right one, like they are claiming, a literal approach is always a flawed one, since even common sense suggests that a plain meaning interpretation of an enactment needs to be checked against the purpose of the enactment. If such can be ascertained, a literal approach is one that ignores the purpose of the provision and relies exclusively on the alleged plain meanings of the enactment in question. Article 49, Article 49 was put there to ensure the integrity of the vote. Okay. That is all.
I know there are those who disagree with you.
Oh, of course. I mean,
who disagree with you that you are saying, yes, it is true that the courts since 1980, 82 going through to 4 and Attorney General, and the one that Chief Justice dealt with, this one, Bonsu matter, strictly, we know that the purposive interpretation is what the Supreme Court has sanctioned and blessed.
But that's what I'm saying.
But to say that the minority did not take that view, you may be wrong.
No, but I haven't said. I'm saying that anyone, I'm not even referring to that anyone who nearly holds on that Article 49 says the presiding officer should sign. If he hasn't signed, everything should be thrown out. It's not following the common sense.
Just 1 minute. Just 1 minute.
Yes.
Simpson. You know what's going to happen in the next election? If I had the opportunity to train polling agents, I would tell them, once you lose an election at a polling station, don't sign.
If we hear it, we'll file a criminal complaint
Don't
against
sign.
you.
If you tell who?
I'll tell a polling agent that once you lose an election at a polling station, don't sign.
It has no effect.
Absolutely.
The majority decision has made it clear.
Absolutely.
No,
Absolutely.
The majority decision.
Absolutely. Because when you sign, it's used as estoppel against you.
No.
No, I'm just saying. So I tell them, no,
All right, thank you.
The judgment has now come out.
Okay, let's hold it
It
there.
has
Let's
no
go.
effect.
Absolutely. So don't sign.
Kwaku.
Don't sign. You lose the election, don't sign.
Kwaku,
Or else it'll be used as
thank you.
estoppel against
Kwaku,
you.
1 minute
But
on the
deciding of-
Kwaku, 1 minute on the entire judgment, and then move on to presiding officers' absence of their signatures, the decisions.
Well, I've listened to the lawyers, and
But you're a complete pocket lawyer for 2 pockets.
I'll be honest, I haven't finished reading the entire judgment. And the little experience I've had is that even if one had finished, it would be very difficult to arrive at very conclusive positions. You need to interrogate the issues, do a comparative assessment of all the rest,
You're right.
go back to some precedents and all the rest. So I'm very cautious in what I say at this particular moment. I've found it quite interesting too, the tension or apparent tension or conflict between what you call the purposive approach and the literalist approach. I've been interrogating that also in my mind. And I have a certain problem. If we are not careful and we overrate the purposive, it could also create room for people to actually sometimes ignore very straightforward mandatory constitutional provisions. We're not sure, we're not careful, it can lead us into that realm. So I think a very critical balance is necessary. I'm not a legal brain. Those who are must interrogate that issue carefully. But you said non-signature, the presiding officer. I've been reading the two, those that I've read, Atuguba I've read, Julius Sansan I've read, and Ene Yabua I've read. These are the 3. And I saw something quite significant in the Julius Sansan thing. And I would want to quote, it says, can the returning officer in a presidential election refuse to sign the declaration form and announce the results of the election and still hope it will still be valid, accepted as valid? If the answer is in the negative, then it's to the same effect where a presiding officer fails to sign the declaration of results portion of a pink sheet at the polling station. So do I hold. If you go to Atuguba, he makes a very interesting point. He says, in this case, it will be unfair and fraudulent for the petitioners to authenticate the results through their polling agent's signature and turn around to seek to invalidate on the purely technical, I stress, technical ground of absence of the presiding officer's signature. It continues, clearly the underlying purpose of the signatures of the presiding officer and the polling agents on the pin sheets is to provide evidence that the results to which they relate were those generated at the relevant polling station in compliance with the constitutional and other statutory requirements. Otherwise, each signature in itself has no magic about it. The evidence in this case clearly shows that absent the presiding officer's signature, those of the polling agents are there. In those circumstances, even if the failure by the presiding officer to sign the same is condemned as unconstitutional, yet the polling agent's signatures, the public glare of the count, and the declaration of the results in question, the provision of copies of the same to the polling agents and their sustenance at the Constituency Collation Center, and all the way to the strong room of the second responder, the Electoral Commission, and the cross-checking of the same threat by the parties, representatives to satisfy the policy objective of Article 49.6. I suspect it may be 3, because there's nothing like 49.6. Am I right? There's nothing like 49.6 there, but I suspect this is a typo regarding signature.
Actually, there are a lot of typos. I think they should pull it and
change
it. I mean, it could be embarrassing. Because it's everywhere. It's
on the surface, these are strong
No, but I'm saying
it's
going to be referred to
internationally. Let's quickly proceed, yeah?
On the surface of things, these are very strong points, both sides. Yeah. But I am more convinced. I think the answer one, when it comes to signature and the effect, is what I will uphold. You see, we are not careful, the constitutional effect of 49.3 is being reduced. I'm not sure if it's a mere technical ground. I think they are raising a very major constitutional issue. The impression I get is that it's been reduced to a mere technical ground by Justice Atugoba, on basis of which then he proceeds to deliver his ruling on that aspect of the matter. I find it difficult to accept that side. See, the 63.9, the EC, the seal, where the EC must 63.9, an instrument which is executed under the hand of the chairman of the Electoral Commission and under the seal of the commission, states that the person named in the instrument was declared elected as president of Ghana at the election of the president, shall be prima facie evidence for that the person was so elected. If this thing is not properly executed, you think you have a validly elected president? We've voted, everybody's voted. Valid votes, the right to vote is indisputable. Article 42. We go through all that process, and at the end of the day, if the EC does not operationalize 63.9, would we have a validly elected president, even though valid votes are being cast by citizens whose right it was to go and cast?
Can I answer your question?
You can. I'm not a lawyer. I'm seeking education and information.
The last line is, shall be prima facie evidence.
Yes.
That the person named was so elected.
Yes.
So it is just giving you how you show that somebody is elected.
It's more than
in the absence of that, what would we say has happened?
Well, the question
I asked was, in the absence of that seal.
Yes.
Right now it is CI, is it CI 80? I think that's CI 80. If in the absence of CI 80, do we have a validly elected president? There were people in the strong room. See, there were people in the strong room. Those in the strong room are in the level, as if, as it were, the polling agents at that level.
Correct.
They looked at all those things. If at the end of the day, the EC chairman does not execute the thing in the compliance with Article 69.3, would we have a validly elected president? I don't think so. You see, in spite of the fact that all those agents may have taken part in the process, and as transparent as it was. My fear, I'm not a lawyer, I'm saying that we should be asking ourselves, perhaps 49.3, maybe based on this Supreme Court thing, as far as I'm concerned, reduced in significance, constitutional significance.
Absolutely.
So maybe we have to do something about it.
That brings me to this question.
You can't.
Let me put this question to Nana.
But that's why I mean that they reduce the effect, the constitutional effect.
Nana, when you read the decision in respect of presiding officer's signature, is it also your understanding that the judges in the majority are saying, in fact, you did not prove your case on this head?
Oh, absolutely, yes. The first point is this, that one, they didn't think that there was enough of those weaknesses to set aside.
No.
Oh, I'm saying that there were 2,000.
That's the fact. You are talking of the fact. We are talking here of the law.
Oh, but please.
Before we go to the facts.
Because they came to a decision. Is that not the correct?
That's correct.
They came to a decision.
Yeah, but we must. No, you see, the point is,
first
let's determine the thing in the face of the law. I wanted that explanation in the face of the law.
I think
before we proceed to the facts.
The law. They didn't go into whether you had enough pink sheets or not.
They accepted.
They accepted.
What is the decision? After you've gotten the decision, it's because you disagree with it.
That's
why you are looking at the minority issue.
Oh, but the decision, the point that both of them have solid ground.
Absolutely, reasonably solid ground. But the point I'm making is that they came to a decision, and the decision was based on the fact, one, that there was insufficient.
They never said
there were insufficient infractions to warrant relief two.
The mathematical aspect.
To warrant a relief two. Don't forget, to warrant with relief 2.
Yes.
And relief 2 is that
invalidate,
they should invalidate the result. All of them. All of them.
Yeah.
Right.
They said you couldn't invalidate.
Okay.
Then secondly, this whole idea about it, they were split. But majority thought that, look, a constitution is a document that is made at a time. But the constitution must grow with the time. That's why we talk about the spirit of the constitution. The American constitution is thinner than ours, but it has grown.
It's open for corruption.
No,
the
all right.
first of the law
You
is
may
voted
call it
for.
corruption,
Okay.
but maybe enhanced.
Gentlemen,
But can I ask him just a question?
just hold on. We've heard all of you on
No,
this
for
point.
him.
We'll take a break. When we return, we are going to look at voting without biometric verification. We'll look at that after the break.
Ready for a rap.
All right. Thank you very much for keeping your dials on Joy 99.7 FM and also for watching Multi TV. This is your Joy News channel. I'm Samson Ladiayani. My guest, Abdul Malik Okubako, Jr., Editor-in-Chief of the New Crusading Guide newspaper. Alex Egbafia is a lawyer and former Deputy Chief of Staff. Nana Atudazi is a lawyer and former Chief of Staff. And Gabi Asario Chiridako, lawyer and Executive Director of the Dankwa Institute. Now,
Yeah, one question.
No, I wasn't former.
all right.
Question.
Capture all those memorable moments during this Hajj season with MTN roaming with up to 60% discounts. You can share all those spiritual moments with your family and friends. So go on, browse the internet, SMS, and call home without worrying about high roaming charges. Travel in comfort with your MTN number and enjoy unbeatable roaming discounts in Saudi Arabia on mobile. Call 786 and follow the prompts to access the Holy Quran, namaz, alerts, and more. Welcome to the new world, MTN, everywhere you go. And I've been telling you about Valex equipment, Valex lease equipment. Are you still buying printers, scanners, and photocopiers in every single office? Be smart. Come to Valex Lease Equipment. With Valex Lease Equipment Limited, you can lease a modern multifunctional equipment which can scan, copy, and print. There is no fixed rental charge. You only pay as you copy and print, and scanning is absolutely free. You can scan directly to email and open with pen drive for free, copy and print wireless to the same equipment. And the good thing about all of this is that the toners and cartridges, repairs and maintenance freely supplied to you, and it is nationwide. Locate Valex at Osuako J near XFM or email them at valex@yahoo.co.uk or call them on 0540 482857 or 0540 482838. Valex Lease Equipment, affordable document management solutions. And also you are aware that Multi-TV is inviting interested people who will like to become world-class installers to join in the nationwide installer training program. The training will be held in Tamale, Wa, Techiman, Sunyani, Seshi, Kumasi, Obuasi, Koforidia, Somenya, Cape Coast, Takrady, Accra, Ho, and Hohoi. The forms are on sale in some selected outlets in the various towns. Contact Multi-TV on 03022111680, 0244340415 or 0244340242 to know where to pick up the forms. Date and venue for the various towns. The cost of the training is 40 Ghana cedis only. Participants will be given a certificate of participation and also an ID card. There are limited forms, so pick up your form now. Thank you very much. I take one or two messages and then we continue. Bright Koforidia, Bright is sending us this message from Nkoko. He says it is very interesting how Alex is reacting to Gabi's comments as against Chachu's attack on a judge. I can see him wearing a big political hat, which seems to be impeding him from interrogating the facts, which is what your platform seeks to do. God save us. Ernest from Taifa writes, whether good or bad, Nana Addo has conceded the final verdict. So all the brouhaha must cease for the innocent Ghanaians to enjoy their peace. Supreme Court justices have done their best, but clearly speaking, God is the best presiding judge in the world. The battle still remains with the Lords. Samuel said, Samson, this pattern of attacking judges and the judiciary cannot be countenanced in the current dispensation, especially from a lawyer. Mr. Chikata should leave Eninyebua alone as he discharged his constitutionally mandated duties of administering justice. Kojo Achirako writes, now all politics must cease. The nation must cease. The nation building is what we must focus on. We must confront corruption and defeat it. JM lead the way. And now I'll take a final one. Obed says that he's sending it for Accra Police. He says, Samson, I disagree with Gabi because Mr. Justice Atuguba ruled against Chachi Chikata in his case at the Court of Appeal. What Justice Atuguba ruled was according to his own observation about the petitioner's case. It's unfair to accuse him, all right? Gabi has not accused him, and in fact, he refuses to join his colleagues in the NPP in the way they are going. I call it illogic, number 2 in my article. All right. Nana, you said you have a question for Kweku.
Well, it sounds a little humorous, but I seriously, I was asking Kweku. Oh, no, not for you. Your heart is too big. Your political heart is too big. But Kweku, how would you have felt if after the vote were to hear that the presiding officer failed to sign, and for that matter, the votes of you and all those who voted in your polling station were thrown out? How would you have, I mean, generally?
Instinctively, first reaction, I'll be very angry.
Very angry,
absolutely.
Absolutely.
But my anger will not be a remedy for a breach of the Constitution.
Yes.
So we'll have to take the matter to an appropriate forum where the decision will be taken.
Yeah. That's a very clinical
But the suggestion, according to the judges in the minority, is not that your vote should be struck out completely, but you have an opportunity to do it a second time.
Yeah, but the point that we're making is that, you see, the whole idea about the purpose and then also the spirit is that the judges try to capture the spirit of the people themselves, the anger of the people.
Thank you. Let's go to the next leg.
This is what Ghanaians
One simple point in 1 minute. Hold on, gentlemen.
A day is a long time in politics. Somebody's view today, when we all voted, can be different in a month or a week. The effect is we want to know how people voted on the day. Don't annul their votes just because of a signature. I mean, really, common sense.
I suppose you are not suggesting that Article 64 will never be activated in this country successfully.
Which Article 64?
That is that the election of a president can be challenged.
It can be challenged, yes.
It can be challenged.
It has been challenged.
Look at Justice Doche's
what I mean is that
look at
you seem to suggest that may be a fruitless exercise.
No.
You are missing the point.
No,
this is a fruitless exercise. Conclusion.
Well, let's come on.
It also creates the impression that it's a fruitless exercise.
No.
Read his conclusion.
He looks at a number of issues.
About the.
He looks at a number of issues.
More importantly, respecting the independence of the Electoral Commission.
More importantly, your approach to interpreting substantial justice. He looks at elections globally. Are they perfect?
And he refused to look at overvoting.
Now, Gabi, we'll start with you. We'll start with you. Let's look at the issue of overvoting and voting without biometric.
Now, first of all, you had 4 justices voting for overvoting, that the petitioners had made their claim and granted it. And you had 4 justices voting for BVD, that voting without verification, petitioners had made their claim. Now, what they meant to say was that the vote to be annulled was enough to have had a material effect on the results, which effectively means that the first limb of the reliefs have been
granted.
granted.
John Mahama was not validly elected.
Absolutely.
But the second leg was also equally not granted.
Absolutely. No.
No,
Equally. That was not granted.
Yeah, it was also not
and
granted.
They gave
that
consequential
Nana
orders.
Akufo-Addo was rather
Precisely.
elected.
The same four. The same five, if you like. Yeah? Same five.
No, sorry, I didn't get what you just
No, let me you had Justice Animi Abua, Justice Julius Ansah, Justice Rose Owusu, and Justice Doche, finding that overvoting and absence of presiding officer's signature should lead to a cancellation or annulment of the vote, and that in those areas we should go back. So what it means is that in their view, in their opinion, in their judgment, President John Mahama was not validly elected.
That's correct.
That's what it means.
No,
please. Let me finish.
And some of them stated emphatically.
No. Please, let me continue.
Because by their calculation of the vote, he would not have
there were two issues.
Yes. That he never got 50% plus one.
Precisely.
So they should rearrange
in those selected areas, not the whole.
Yes, that's
exactly.
Apart from Animi Abua's.
That is right.
In the same.
Yes.
Okay. Good. So that's four. Then you get to. That's four people. Individuals.
Yes.
Then you get to voting without biometric verification.
Yes.
There you have Justice Julius Ansah, Justice Animi Abua, Justice Rose Owusu, and Justice Bafo Boni, saying that they are granting the claim of the petitioners and that there should be a rerun of the election, which means President John Mahama was not validly elected.
That's correct.
Okay. Now, if you put the number of individual judges who concluded upon looking at the evidence, the constitution, and the laws governing how election petitions are supposed to be looked at, you have 5 out of the 9 justices concluding that President John Mahama was not validly elected.
Not true.
But the evidence is here. It's here.
The evidence is not there.
It's a very wrong way of looking at it.
Please. As far as we are concerned, as far as the court told us, they said that there were 2 issues they were going to look at before they can get to the reliefs. Okay? 2 issues. Whether or not there were these malpractices, omissions, blah, 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 and whether those omissions, malpractices, irregularities had any effect on the election.
If they occurred.
If they occurred, if any. 5 of the justices concluded that there were these irregularities, infractions, or whatever you want to call them, and that they had an effect on the results. 5 justices. And then the day that the decision is given, and that's why some of us think there's a sense of what's or fast.
Gabi, again, explain 4 or 5.
5. Because look, you have Justice Bafo Boni, okay? All right, who states clearly, I will therefore uphold the petitioner's claim on this ground, i.e. voting without verification, only to the extent that those voters that have their votes cancelled should have the chance to recast their votes, lest they be disenfranchised, okay? And then he goes on to accept more or less the evidence given by the petitioners. And the votes involved there, okay, they are 816,666. And the results of that, if you cancel those votes, brings President John Mahama down to 49.25%, Akufo-Addo 49.25%. Now I'm saying that the court told us that they were going to, these are the 2 issues they've set, and after that, they will see how many of them would agree that, 1, the first relief should be granted, 2, whether or not the second relief should also be granted. Now I'm saying, no, please, I'm saying.
You are mixing.
Okay,
no, I'm not mixing.
I'm
not mixing.
Okay.
I think we need some explanation.
Can I ask you to address this? Can I ask you to
Let me
address
finish.
this?
Let me finish.
Can I ask you to address it? We have very limited time now.
Yeah.
We talk about voting without biometrics.
Yes.
For example, a judge says you didn't even call a single witness to help to prove that case. You didn't prove it. What do you say to that?
The fact is, look, the evidence is the pink sheet, okay? the Electoral Commission, who basically, the chairman and the commission, also did not call any witness to show that what is on the pink sheet is not what it says.
The onus is on you.
But I'm just saying, at the end of the day, 5 justices found for overvoting. Am I wrong? Including Bafuboni. Including Bafuboni. Bafuboni found that the petitioners had made their case on overvoting, except, I don't know how he made his calculations, but said that the votes were insignificant. I can read it to you. You've read it. You've read it.
It doesn't say that.
Okay.
Oh, I'll read it. Please. No, I will read it. I will read it.
Oh. Discussion.
What you are saying is very wrong.
No,
can I just say one thing?
Please, why would I do this?
He's comparing apples and oranges.
He's looking for Bafuboni.
Yes.
Yes.
However, this is page 538, Bafuboni. Aside of these many errors, which may be described as clerical, there were also very many pink sheets which recorded cases of actual overvoting, i.e., where rejected ballots and valid votes put together were more than persons actually verified to vote. However, sifting the ones actually affected by overvoting from the many affected by the many clerical errors, one is left with very few pink sheets whose results will not impact positively on the outcome of the overall results. I would therefore dismiss this claim on account of this ground. Now look, you go back, he tells you that I must say that I agree with the petitioner's definition of voting.
The instructive phrase there is that I will therefore dismiss this claim.
And I disagree with him, and I'll tell you why.
First of all, don't go there.
Please, I can do
don't go there.
I can disagree with him. You're a lawyer, please. Don't. Why? We can't speak? You're a lawyer. Please, don't say I shouldn't go
Not
there.
yet.
He admits.
Gabi, you ought to be finishing your point because I need to move on.
They were overvoting and concludes, without giving us any evidence, okay, as to how he made the calculation, whether he used the roadmap of Justice Docho or not, that those were not significant. And let me tell you why he's wrong. First of all, he has found that within BVD, there were enough votes to have an effect. Now, once you have found within a category that there were enough votes to have an effect, even if you find 2 other infractions from any other category, that category doesn't have to have an effect because already that effect has been established.
Okay.
You know, when some of us say that this judgment is farcical, this is what we mean by that.
Oh, I see. Thank you, Gabi. Now let's move on, Nana.
5 people, 5 judges found that there were infractions to have affected the results.
Overvoting and then voting without biometric.
Yes, I want to address it, but just I think that Gabi needs to go back and read the judgments again. That is the bottom line.
I've read it like you.
Listen, I'm looking at the judgment of Mr. Justice Doche, and this is what he says. Issue 2. In the last majority of the categories, I can conclusively say that...
majority.
Yes, in the vast majority of categories, I can conclusively say that they've had no effect on the outcome of the elections whatsoever. Yeah. However, when cumulative put together, the self-evaluation may affect the outcome of the election. Decision on this duplicate serial number, that's page 446. Duplicate serial number, voting without biometrics. Voting without biometrics. Unknown polling station, duplicate polling station is that I reject those claims outright and no consequence arises. Here he is sitting down that Justice Doche this. Sorry, there were 5 of them. Yeah. He certainly was on one of the 5. Then 2.
On where?
On where? Please, I'm
on
coming.
Where? Which one?
I'm coming.
I've read all for overvoting and absence of presiding officer signature.
I'm saying
we're talking about overvoting and voting without biometric.
I'm saying I'm reading from here. You have I said
go back
but the most significant, the next page. If you turn the next page, 447, he specifically says relief 2. And you know what relief 2? Relief 2 is where the petition was asking that Leonardo should be made. He said relief 2 is
read relief 1 first. Read. He says the petitioners would be deemed to be successful in respect of their relief 1. He says that.
What is it?
Yeah, he says that before you get to relief 2. He's granted relief 1.
No, I'm saying that you... No,
5 people granted relief 1, and yet we are still sitting here.
This filibuster will not help you.
Okay, go on.
I'm saying that it says that the petitioner's relief 1 will therefore be granted in respect of the law presiding officer. you know,
It's an ass.
Now it's a relief to it. However, accordingly dismissed. That is the request to set it aside, the. But then he said that I would direct that there should be a rerun of the presidential election in only the affected stations between the first and second. Look, there's the presumption that the man has been elected. Now, somebody is challenging it. Now, then he says that rerun, if in the rerun there's a minus 50 plus 1, then you can, the consequence will follow. But that decision itself has been overtaken by the majority decision. But you are sitting here saying
majority? Which majority?
Okay, I'm not going to follow you. But then let me get back to the biometric thing. But I'll basically say that those 2 points. But
Nana, I would also suggest that we may need time to look at the judgment closely.
Oh, yes.
And convince ourselves with the training, with the eye of a lawyer, that you can say that is a majority decision.
Sam,
I'm telling you.
But move on.
Move on.
That's all right.
I'll move on.
It is not a majority decision.
Gabi, you have made the point. Gabi, you have made the point.
It is not a majority decision.
As a lawyer, I'll be shocked
It is
by
not
any
a
statement
majority
from
decision.
a
That's
lawyer
what I'm saying.
who will say that the verdict we have
not
here
a majority
is not,
decision. The
is not
issues they set for us is not how they concluded.
Gabi,
Can I
No,
just
let me
step in? I want to, let me just make a very important point.
Yeah.
You are using 2 separate tests.
The test they told us.
No, but
that's what I'm using.
Please, listen, Gabi, you've had your say. Let me speak.
Go on.
They gave us a test. It was a 2-tier test.
Correct.
But what they did in their judgment was to answer what the petitioners brought in theirs, which was a different test. 6 different categories. And they each made a decision on each of the categories. You cannot use that test and mix it with the categories. If not, they shouldn't have talked about the categories.
Unless Gabi is saying that they are not entitled to approach it the way they do.
Exactly. That's different.
But who is it?
But
you know the Opis case they
please, let me land.
Okay, let's not finish this point.
What I'm saying is that because they took the 6 separate ones and made decisions,
that's where
you are doing a mathematical calculation which is unfortunate.
Thank you. Nana, finish your point. Finish your point in 2 minutes.
Please. I think that for the majority, it was a basic thing.
Which majority? Your majority.
On the biometric and what we were voting, the sense of what I get them to be saying is basically one, there was no evidence or hardly any evidence, or the evidence towards seeking to set it aside was weak. Secondly, they also say that the evidence that was required didn't really come up. You know that, for instance, in respect of
Be careful of the majority. They came through different ways of getting to where they wanted to get to.
Gabi,
No, I'm just saying.
Gabi, let him land.
No, but if you say majority, some did not go the way
Gabi,
you did.
you see, you have made your point. Unless you feel that you have not been able to communicate effectively, let him make his point also. I beg
That's
you.
a bit mean.
Sorry about that.
It's fine. It's allowed.
I'm here. I'm expecting the sorry from him. You know.
I'm sorry, Sid.
Don't show my ego for anything. You know, the point is that one expected that once you come into court, you come up with evidence. And there's a way that evidence is led. And there's a way that you procure evidence. Now, if you say biometric, people voted without, going through the process, you must produce evidence to show that. When in the long cross-examination of Dr. Bawumia, he does admit that he doesn't have anybody coming up, but that it was on the face of the pink sheet. His evidence is on the face of the pink sheet. Now, the interesting thing about it is that Justice Ansah says that he believes Dr. Bawumia, because the document comes from proper custody. You get me? But the problem with that is that from official records, now even that official record, it wasn't Dr. Bawumia, who entered them. So you cannot respond to them. And that is why when you ask any question, you say, you and I were not there. So essentially,
but the was there.
Essentially, his evidence was hearsay. You get me?
Oh.
And then the
pink sheet was hearsay.
NDC provided about 7,000 witness
4,000,
evidence.
half of them were duplicates.
please.
Gabi, let him land.
Oh, let me land. You see,
what he's talking about, the judges commented.
They commented
as well.
on it.
So,
I'm talking straight from the judge.
Go on.
The judges indicated that, look, the burden was on the petitioners to produce evidence, real evidence to show that people voted without going through the biometric. The allegation had been challenged by the respondents, who said that yes, there was a challenge the first day, but they moved into the second day and everybody else voted. Then they produced affidavit evidence of about 4,000 or so people, which you did not challenge in an affidavit.
Oh, it was challenged.
Oh, you did. You could have called them. You didn't. But you yourself,
4,000 people.
You yourself, you had an opportunity of calling people to testify to that.
A judge actually said.
You
just
didn't
one.
even call one.
Yeah.
Okay. So the way your case was handled has a lot to do.
Okay.
So
Nana,
don't try
today, I must admit that we are constrained by time.
Yes.
In such a very tight way.
Yeah. You want to win.
Now, Kuku, let's hear you.
Well, as I said,
over voting and voting without biometric verification.
I would not pretend to have done any serious analysis yet, but I found certain things quite interesting. Because of the thread I have read, in terms of Justice Atuguba's handling of overvoting.
Half a page.
The point about,
he dismisses it with dispatch.
I'm pondering, yes, the first is where the number of those who voted at the polling station exceeds the number of voters contained in the relevant polling station register. The second situation is where the number of ballots in the ballot box became book exceeds the number of ballot papers issued to the relevant polling station. Pondering over these two categories closely, I would think the second category of voting is rather an instance of ballot stuffing, as testified by Johnson Asidi Nketi. I'm confused.
And
I have to be very honest with you.
He doesn't make any analysis.
I do not understand that, and I don't think that's a fair representation that what we should get from Supreme Court judgment, to be honest with you. Then there's point about voting without biometric.
Maybe if you read him prior to that,
there's nothing.
I saw
what he does before he gets there.
I did. But I think the conclusion
will justify the way he dismisses it quickly.
Ballot stuffing by which means? The unidentified material.
It's no excess
what
votes.
was it? It's excess votes. You see, and he talks about the process that Farijan referred to as to how they could clean it if the thing came to their notice. So, but it is not ballot stuffing, it's excess ballot. But I found this very intriguing. Maybe I'm wrong. This is page 26. He says, this is biometric, I am not aware of any judicial university that has awarded or conferred a graduate or doctoral degree on the pin sheet.
What was the meaning of that?
Yeah, what was the meaning of that?
What's the meaning of that?
Gabi, please, hold on.
I think this is actually a below-the-belt shot at the second petitioner. And I again don't think this should come in the form of a Supreme Court judgment. I'm be honest with you. The last point.
Right.
In the circumstances, I do not think that the petitioners have established the allegations of overvoting and voting without biometric verification, except to the limited extent admitted by the Electoral Commission's chairman, which cannot impact much on the declared results.
Right.
I'm at loss. Where is the statistical base for this conclusion? If it's there, fine. If all you know it's there. But it's missing in his judgment. I find it difficult to appreciate that.
But the admission was a sampling of the same instances.
That's my view.
Okay.
If you read,
so he didn't bother to read
him further.
Let me
what you get is he never.
If you read him further, you may hear him talk about a belated attempt by the petitioners to now adduce evidence to prove that point.
No.
Which point?
See, he makes the point about
he's even wrong there.
Except to the limited extent admitted by the Electoral Commission's
So he's
chairman,
accepted.
which cannot impact much on the desired result. I realize other judges did some statistical evaluation and gave figures.
No.
I think it helps. But as I said, everything I'm seeing right now is very, very, very on the note of caution and a certain inadequacy. I don't think it's fair.
From a layman's view.
Yes, and it's also the fact that I have not done a comprehensive scrutiny.
Right.
I want to be fair to all of them. The little I've read, everything looks solid, but you have to subject it to further interrogation to get a drift. Within the context of the fact that we've all accepted the judgment. That is the key point.
Something, just one point.
Gabi,
you know, you find in 715 polling stations where Justice Doche and Justice Bafuboni, they meet. You know what I mean? What I mean by that is that there are 715 polling stations where you have voting without biometric verification and overvoting or absence of signatures. So these things happen at the same polling station.
Thank you.
And what? They've ignored them.
We should never have even gone there. For me, we should never have even gone there. Because evidence production is a different process.
Okay. Can I just say that?
Alex,
if you take signatures.
I was hoping that you could help me approach it in this manner so that we can address one other issue about the implications of the judgment on future elections. For example, what is your understanding now of what represents overvoting? Classical definition or Baumia's second definition?
I think it's a red herring. I think it's a red herring. Why? No matter the definition that you put on it, in terms of whether you think it's ballot stuffing or the figures don't add up or you think that it's the people who have got, the people exceed the number of people on the register, etc. If you are able to prove that these issues happened sufficiently before any court, it will be upheld.
So you are saying that it's a question of proof?
It's a question of proof. You must prove your case. If you are, it doesn't, for me, so what is then the definition?
Don't you think that as a country, in a situation where they are making suggestions or recommendations for electoral reforms, don't you think that it is important that we have certainty in what represents overvoting?
The point is that depending on the definition you put, you can clarify this issue at the polling station in more cases, more so than others, if you depend on your definition. So if, for example, you went into that box and there were 100 ballot papers in it, and there were only 80 people who were allowed to vote there. In other words, on the register, there were 80. And you checked the 100 sheets, and all of them turned out to have come from within that scope. You immediately say that it's overvoting, it goes away.
You don't think that because you yourself, you are unable to now say what represents overvoting categorically, the Supreme Court has not been helpful in this regard?
Thank you. No, well, why? Because when I think Afrajan's line was the best, he says, look, listen, yes, he says, look, I have a classical definition of what I knew as overvoting.
I have a high life.
Two other instances of issues have arisen. I'm not in a position to dismiss it. I'm not in a position to dismiss it.
That's why we told the Supreme Court at the end of the day, without giving us the way to
some are saying,
Justice Doche did absolutely well.
I must say. My point is simple.
He did.
Justice Ansah prefers the second definition, which is
so let me ask the question.
The vote cast in excess of ballots issued.
So what do you call
Justice Atuguba is in favor of the classic?
Please, let me explain something. You see, this is why I said that it's a red herring. Hey, there it is.
Okay, I must announce that the show will end at 12:20. Okay. Unfortunately, it appears that if you do not have the benefit of the TV, you may not get it. But I understand they are working to ensure that we get it both on radio and TV.
Okay. Now, why am I saying this? For me, all the various types of irregularities that were put forward by Bawumia, if proved, will demonstrate that something was wrong at that particular ballot polling station. So whether you call it overvoting, stuffing, once you're able to prove that this thing was wrong and happened, it is implied that the court has to take cognizance of it. So why are we worrying about whether it's called ballot stuffing or overvoting or whatever? Fine.
Why was it difficult for the Supreme Court to give us a certain definition, especially when one of them conceded that there was no definition
because
whether in the Constitution
we have and the courts in their judgment, all of them acknowledging the confusion.
That's right.
Yes.
That even
so
the
you can use the word malpractices.
So you can use
the word what's it called? Irregularities. Yes,
but majority of them appear to accept Dr. Bawumia's definition.
For me,
Justice Doche
you can
go
call it
ahead
an
to do a lot more work on it. And I think he did excellent work.
Irregularity. You can call it a malpractice. You can call it overvoting. You can call it what you like.
But it's important.
But it's important to prove it, and then it will be taken into cognizance when you are making a decision whether to annul votes or a rerun has to be.
Okay, may I
so I don't
that
have a problem with how Bawumia looked at it and said this is. It's just that he used the word overvote.
May I announce that if you are afraid of the risk of losing us on radio, just log on to www.multitvworld/streams. You can have access to the streaming and listen. And then myjoyonline.com. You can also access it as well. Now,
that's a very important point.
I think my iPad is
Gabby's rendition. Look, if you read the judgments and you follow Gabby's logic,
it's not my logic.
It is your logic. Let me tell you why.
Your interpretation of the Supreme Court's logic.
They said the issues.
Right.
Gabby's logic is that if you read the judgments, almost all the judges make the point that actually point number 1 of signatures amounted or implied from their statement amounted to some irregularity. Their interpretation of that irregularity is what they didn't go with. So you can say that all the 9 or 8 would have said or agreed that the lack of signature of a presiding officer amounted to an irregularity or...
but that is in the Constitution. There's a provision for that to happen.
You are not listening to what I'm saying.
But the overvoting, as they considered, that nowhere in our statutes...
You are missing the point
I'm sorry.
trying to make.
I'm sorry.
The point I'm trying to make is that if you looked at it like that, you would say, as Gabby is saying that on the first point, you would say on the first question that had they used their definition that they told us from
Memorandum
the beginning,
of issues.
we will look at, first of all, whether there were irregularities or what, and then secondly, we will look at what the effect of it was.
You said issues and you ignored them.
Now,
Supreme Court.
No, they all came to the conclusion that in their judgment that we are going to deal with each category set out in your petitioner statement, category by category.
Yeah, there's 6.
There's 6.
But those were in the pleadings before they said the issues.
Okay.
And because of that,
but it was within their right to...
Exactly.
And once they did it, but the reason why I'm saying that is important is that if not, I can also do Gabby's type of calculation and say that
it's not my time.
The decision was 9-0. If you ask a simple question, the simple question is that over the overall total, was the effect that President Mahama remains president? The answer from the Supreme Court
is yes.
Yes. So it's a 9-0.
That's
okay.
That is the type of calculation.
Go ahead.
but you know, as a lawyer, that is not...
That is why I'm saying, as a lawyer, you shouldn't use that 5-4. That's not the way to do it.
Alex, the exercise...
5 of them found that John Mahama was not validly elected.
My question...
How can you be...
My question was to help, was to assist the exercise to clear the minds of the majority of the people who are listening to us. To be clear about what represents overvoting. You have stated it, what you think should be the case. It's a question of proof, really. It doesn't matter what you call it. Then, secondly, there was a question of voting without biometric verification.
There was a very interesting point
The
there.
petitioner's point is that it is mandatory to be to be verified by the machine, use of your finger, except the exception to people who have suffered some trauma, who do not have fingers. Otherwise, you have breached or you have exercised a discretion that is not given you by CI 75, Regulation 30 thereon. Then, the respondent's position was that it shouldn't end there. It must not be the case that it is only through the use of the machine and by placing your finger on the machine, but FO as well. What now is biometric verification?
I think there are 2 points that you have to take from this, the respondent's case and from the judgments. What is said first and foremost?
So don't be afraid. I understand we are on radio as well, so you don't need to go logging on where you don't have to.
What is clear in the first instance is that the case of the EC which has been put in the judgment is that there was no voting that took place without verification. That is where you start from. A second argument was put in by Tonita, which was also adhered to by one of the judges, which is that even assuming it did take place, you cannot just say verification is the verification itself is a process. And you cannot say that by virtue of a failure by the body that is actually dealing with the process, they didn't get a machine available, somebody should then be disenfranchised. That point was not, as far as I've got two more judgments to read, but as far as I can see, was not fully addressed by the court. They just mentioned it without saying one way or the other whether they believe that this thing. But one of the judges made it clear that no, it's important that there must be verification by the machine. But the key, which my colleague has alluded to, is simple. One of proof. If you rely strictly on the pink sheet, you can come up with all manner of permutations and what's it called? Conclusions. But there are other primary sources that could have helped you to get the clearer picture of what happened, either by looking at the pink sheet on its whole, or by going to look at the register, or by going to check from the machine itself, and that would have told you. But the best part would have been to get 1, 2, 3, 5, 10, 50 people who said, I was at this station, the machine didn't work, and I was allowed to vote without verification.
Right.
And that was not, they didn't have any evidence of that.
Thank you very much.
And therefore they couldn't see how
Thank
there
you.
was proof.
Thank you very much, Alex.
So
now gentlemen, this is what I'm coming to do.
Because you can be checked.
You're going to attempt with about 2 minutes each. We need to move on to the Nanado, the calls for him to do a third, time. Yeah. Kweku, I'll start with you on the question of whether now you are clear in your mind what constitutes overvoting and what constitutes what should be biometric verification.
As I said, I haven't exhausted my study of the 9 separate judgments, so I have to be very careful what I say. But I've studied Justice Atugubes, Justice Eniya Boas, and Justice Julius Ansang. Sometimes some of these things, what you end up saying is also informed by what your own position was. I've noticed that, even with the lawyers, and we had a long debate on this point. But to be very fair with you, when I look at Justice Atugubes' approach towards overvoting and voting without biometric verification, and that of Justice Julius Ansang, I find Julius Ansang is more convincing in terms of the way forward. We are heading towards a certain certainty, which is not yet with Ansang's done with Atugubes. So that's the problem I have. But, because I was wondering, overvoting, we shouldn't have been arguing over it seriously. Overvoting is overvoting. But here we are dealing with ballot stuffing and overvoting and which one. I think it's clear that Bawumia's account, which Justice Ansang accepts, is a more credible definition. And I would have loved if the Supreme Court, in spite of the final verdict being in favor of the president, had also been able to itemize in order to help us that, look, overvoting, this is what it constitutes. But perhaps the challenge there was that if they had done so, then it would have affected the overall verdict, I suspect.
All right.
So I suspect. So I think that something, I believe so. It's logical. It's a logical deduction I'm making.
Okay, I said 2 minutes and I meant 6, yeah.
Yes.
Okay, thank you, Kweku. Do you have any confusion about the two issues? And do you have any fears going into 2016 election?
No. I think that, first of all, I have total and absolute confidence in our electoral system. It needs some tinkering, some reform, and all the judges said. Indeed, I was looking out for the reforms that would be proposal will come up. And essentially, the reforms are in the area of administrative reforms, not the major system. No. They will agree that the main vessel, platform is okay. But we need to do, like just Joche at a point said that some of the presiding officers appeared almost illiterate.
Somebody will say that Justice Joche is justified to make recommendations for reforms.
Yes.
Because he admits that the system is broke.
Yes.
If it's not broken, what do you have to fix? Those who say, in the end, look, petitioners dismissed.
What are they recommending? No. I think that throughout the trial, we all got the impression, and the conclusion of all the judges was that there's need for more training, there's a need for better, the standards should be raised and all that. There's no two ways about that. But when you address the issue of overvoting and the not biometric, I think that the majority decision was based simply on the fact that the pink sheet was not enough. Secondly, the problem about overvoting, as Alex Riley put it, I think that we shouldn't, hype it. It's simply a question of the ballot in the box. Is it more than what was issued out there? You get me? At the end of the day, everybody is there, and everybody will testify whether there are more there. But they all identified a problem, and that's a C column. And there's a C column, it's an issue whether it should have been filled or they should have been there. So that is all. But I'll tell you something.
The EC says those entries were in error.
I'll tell you something. When the judges say that, most judges say that, look, the petitioner's case does not add up because they fail to call other evidence. It is because of what they themselves had admitted. Among the things in page 64 of Justice Ansah's report.
30 seconds.
Yes, I will. And it says, 1, votes for the first respondent from same polling were illegally padded. The duty of the court was to determine how the evidence supported the facts alleged. The court will subject the evidence before it to microscopic analysis to determine its probative value. But before then, I must observe that the petitioners no longer relied on some of the allegations they made. They talked about the padding and favoring, allegation of clandestine, the STL. But then the last two things, they said no evidence was laid on ballot stuffing by anybody during the voting. Now, 6, there was no allegation made that somebody who wanted to vote was prevented from doing so. And 7, that a voter whose name was not on the register nevertheless attempted to vote. That is a platform.
2 minutes, strictly.
What do you want the judges to do?
2 minutes,
again?
strictly. Are you confused going forward? 2 minutes, strictly.
What do you want the judges to do? I think the judgment is potentially dangerous for our democracy. Potentially dangerous for our democracy. And I think it's important that as civil society, political parties, the media, EC, and all that, we sit down and as much as possible ignore the judgment, the areas that we have difficulties with. Is done.
You're repeating what you had already said originally, that we should ignore the judgment.
We should ignore the judgment.
What did he say? Ignore the judgment.
It's part of his original statement.
That he feels that they have.
No, that is not in a democratic constitutional government.
It's done. It's finished. It's finished.
And a very subversive statement.
Focus on the stuff that we have to do to make our electoral system better. I mean, Justice Atuguba, page 25, I'll say, neither the Constitution nor any other statute, substantive or subsidiary, has accorded the pink sheet any particular status. Yet, when you go to Article 49.3, it says that the party contesting or the agent, the police agents, if any, shall then sign a declaration. Where should they sign it? On a blackboard? When the Constitution says that you should sign the declaration, where does the Constitution say you should sign it? On a blackboard? Of course, it is what the EC has interpreted to mean a pink sheet.
You've got 20 seconds.
But the judge basically said the pink sheets contain errors of omission, as proxy votes, blanks, repetitions, wrong grammatical renditions, so let's ignore it. Yet, let's uphold the validity of the elections. Because he concludes that courts, and if you remember what he said courts find it difficult to invalidate elections. And of course, he will not do so. But the most important thing, as far as I'm concerned, it is over. I think Ghanaians have behaved very, very well. We have stuck to our appreciation of the rule of law. The petitioners... Oh, I have.
Except you.
And rule of law also means I have the right to critique it.
That's correct.
And I can do it harshly. And yes, I mean, I will respect my right to freedom of speech.
You can do it harshly. You don't have to scandalize. You don't have to abuse the courts.
As I tell you, I haven't accused any judge of corruption.
Gabi, let me start this one with you. Yes, there are calls all over that Nana should make it a third time?
Mm-hmm. I mean, let me first talk as a family member. As a family member,
family of MPP
no,
or
no, I'm
family
saying
of Nana?
Nana, yes.
Okay, I wasn't sure.
Yes, I think, you know, look, I mean, I saw him in 2010, 2011, walking 5 hours a day, greeting people. He went somewhere, they even pulled his shoulder off. You know, so he had to stop his campaign. I'm just saying, I've seen him gone through all this, you know, and I think it's a heavy toll on the man. I mean, he's done it. He's been there 40 years, you know. So from a family member point of view, I feel for him. You see what I mean? But you know, I think it's not about.
So he should take a bow?
No, he says he's taking a break. Let's allow him to take a break.
So he should take a break.
And then he will take a decision based on his consultation with his God and based on what he feels. I mean, because really, political ambition is not necessarily driven by what you feel in a democratic environment. It's not about how you feel. It's about how the people feel about your candidacy.
All right.
You know, so as far as I'm concerned, the man has asked for a little break. Let's give him that break. And when he comes, he will take a decision based on, first of all, himself, his party, his God,
but
and
your
his
critics
nation.
say what is going on is not in consonance with what you claim to be a democratic party. Internal democracy must work. People should be allowed to compete. But it looks like you're running ahead of everybody else.
I doubt that very much. I mean, as soon as I heard Sir John on air, I went to his house. Yeah, because I went to his house. I said, John, what's going on? I said, Gabby, will you sit down? And he showed me his 4 phones. And then he started picking his phones. He's getting calls from constituency people, from people everywhere. And he said, I have to say something to them. This is the explanation he gave me. There are people, they are calling me every minute. You don't know how he feels. So I have to tell them something. You know, but that, no, I'm saying, no, he lives about 3 minutes walk, 3 minutes from me. So I went to his house when I heard that. And he said, I'm a general secretary of the party. These are the calls I'm getting. I need to speak to them. Later on, we go through the processes. We are not going to abuse the constitution of the party. We go through the processes. So but like I said, Nana needs, I told him, I beg you, you should stay off. And he said he's not going to say anything. But he said he was responding.
Let me hear you.
He was responding to what the grassroots was saying.
Let me hear you 1 minute on this.
1 minute, I would say that
if you were to advise Nanado
as a friend,
yes,
I believe that he would say I'm a friend. I would say that he's fought a good battle. He's been honored by this country within the last 1-2 weeks, where everybody is saying that he's played a statesmanship role, and he should just stick to that for now. I mean, but of course, the decision is his, and the decision is his party, because you can also endure. One of the greatest statesmen in this country who never held a political office was Dr. J.B. Dankwa. Do you understand? I thought you'd be saying that. You don't have to be a politician in that sense, or hold a political office to be remembered down the ages. So I'm saying that no matter all the negative, there were times people said he was a very violent person. Right. There were times people said he wasn't even a lawyer. There were times people said all kinds of things. Today we are all saying he's done a great job by taking a step in the interest of the country. Why not? I think he should just stick out there and then remain.
All right.
And I congratulate him.
Thank you. Alex, he's got an opportunity for the first time. He doesn't have to contest. He's been giving it on a silver platter.
Who says so?
Should he? Oh, that's what they are doing.
What do you say?
The party chairmen around are all saying, the people are calling and they say, it is you we want.
You
come.
Stick with
and
the
that without you,
stick with the reporting,
we are not
leave
going
the politics
forward.
For we the politicians.
That's what they are saying. I'm reporting to you what the party chairmen are saying.
When the time comes, you will then see really what is on the ground. Okay. I don't agree with you in the least. That I know he has got a tremendous support base. Don't get me wrong. He has a tremendous support base, but there will be a contest. It's not going to be a hands-down issue. There will be a contest. If not so, what you are saying now means that he's going to go unopposed. I don't see that.
maybe
contest may be a non-contest.
Well,
but there will be a contest. You're right. That's if he decides to run.
For me, I only mentioned that, but let me just be clear. We are waiting for anyone who is coming. John Mahama is in pole position.
What I
will
hear,
remain in pole position.
What I hear is that what I hear is that the NDC's fear will be that this is a man who was almost got it. So if he's going a second time, he's likely to get more votes to add up to make him the winner. So you are afraid. If he comes in, that's trouble.
Why would that fear exist? Somebody else can also
5 million like
somebody
John
also
Mahama
can say that John Mahama campaigned for 3 months. And was able to beat somebody who had been campaigning for 2 years.
Remember what he was saying in 2008?
When we get to a point where he has only campaiged for what? Yes, but Professor Mills.
All right.
I can say a lot of things.
Sorry.
But I'm just saying that whoever they bring,
you're ready.
Whether that's why I'm not saying you shouldn't contest. Let me
hear from.
I'm just interested in knowing that whoever MPP bring.
Let me hear from.
John Mahama and the NDC, we are waiting for you.
Thank you very much. Let me hear from Kweku Bako. But I must announce some of you are asking about for the number for Latida. 0204 336 444 0204 336 444. That is Latida. They give you the cheapest but the best in African print. I'm sure you like what I'm wearing. Yeah, Kuku.
My brother, see, within the context of Nana's statement that he was taking a break to reflect on his political future and the party's announcement of a certain calendar as to what the party intends doing from below to a certain level. Even if a general secretary of a political party had the evidence Gabi is pointing to, an aggregate of sentiments from the grassroots as to what they would want the party to do come election 2016, I think what the general secretary did, and he's been supported by other leading members of the party subsequently, is a reflection of the poverty of their management skills, their leadership capacity when it comes to how to organize a political organization. The timing of that announcement by the General Secretary, supported by others, has only created some source of distraction, factionalism. Go and listen to the air. The party doesn't need it.
All right.
This is a party that has come out from a court case. You even set up a committee to review the findings.
Right.
You have things to do as a party.
All right.
Then you jump the gun. Look, let me repeat what I said on Metro. It amounts to premature ejaculation.
Oh, gee. Thank you very much, Abdul Malik Kweku Bako Jr., editor-in-chief of the New Crusading Guide newspaper. Alex Segbefia is a lawyer, former deputy chief of staff. Nana Atudazi, a lawyer, and a former chief of staff. Gabi Asario Chirdako is a lawyer and executive director of the Dankwa Institute. This show is repeated at 9:30 p.m. on this very channel, so you can watch again. I am Samson Ladi Ayenini. Thank you very much, Nana Atudazi. You've been with us throughout the petition. Thank you very much. When we do need you, we'll call you and we'll hope that you will respond to our call.
Thank you very much.
Have a good afternoon.